All right, so I think we're pretty good. Jim, can you start recording?
Yep.
So when you say, Carl, when he says gives us the okay, you're ready to roll.
Yep.
Okay, we should be recording now.
Okay.
All right, all set.
Okay, good evening, everyone. Welcome to the Hillsborough Township Planning Board public meeting of February 4th, 2021, scheduled to begin at 7:30 p.m. It's actually 7:37 p.m., making sure that all the attendees are in-house. Please note that this meeting will be conducted virtually. All board members, staff, and consultants will be participating remotely. The public will be given an opportunity to participate remotely through the advertised Zoom link or optional phone number identified in the public meeting notice. Members of the public should use the raise hand feature in Zoom or by pressing *9 if participating by telephone to get you would like to be recognized to speak. Meeting and application documents have been made available at the township website in accordance with the public meeting notice. Applicants will be presenting remotely and will identify themselves before testifying. With that, please join me in a salute to the flag. I pledge allegiance
to the flag
of the
of
United
the United
States
States of America,
and to the
the
republic
republic for which it stands,
one
one
nation,
nation,
under
under
God,
God,
indivisible, with liberty
Liberty and justice for all.
justice for all.
Please be advised this meeting has been duly advertised according to Section 5 of the Open Public Meeting Act, Chapter 231, Public Law 1975, otherwise known as the Sunshine Law. Notice of the 2021 annual meeting schedule has been provided to the officially designated newspapers, the township clerk, posted on the bulletin board at the Hillsborough Township Municipal Complex, and posted on the township's website. Additional notice has been provided to communicate that this meeting is being conducted according to the governor's executive orders and pursuant to Public Law 2020, C-C.11, which allows for meetings to be conducted electronically and pursuant to the local finance notices recently established in the state of New Jersey. First up, we have oath of office for newly appointed members. We have Nate here for seat number 7. Eric, would you like to do the honors, please?
Mr. Santa Marita, would you raise your right hand? I state your name.
I, Nathan Santaramita,
Do solemnly swear
do solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of New Jersey,
and the Constitution of the State of New Jersey,
and that I will bear true faith and allegiance
and I will bear true faith and allegiance
to the same
to the same
and to the governments established
and to the governments established
in the United States
in the United States
and in this state,
and in this state,
and that I will faithfully,
and I will faithfully,
justly,
justly,
and impartially perform
and impartially perform
all the duties
all the duties
of regular member,
of regular member,
seat 7
seat 7 of the
of
Township
the Hillsborough Township Planning Board
of the Hillsborough Township Planning Board,
to the best of my ability,
to the best of my ability,
so help me God.
so help me God.
Congratulations.
Thank you. It's a pleasure. Thank you.
Welcome back, Nate.
Thank you very much.
Okay, next, can we have a roll call of board members followed by a roll call of the board and township professionals?
Mr. Scobo, Mr. Wagner, and Mr. Hestag are absent tonight. Mr. Emick,
Here.
Mr. Chicarelli,
Here.
Mr. Santa Ramita,
Sure.
Mr. Peason,
I'm here.
Deputy Mayor Delcor,
Here.
Mayor Lapani,
Here.
Vice Chair Julian,
Here.
Chair Srirachi,
Here.
and Mr. Kinsler.
Here.
And Mr. Horry.
He might be muted. Jim, you there?
Here.
Great. Mr. Maskey,
Here.
Mr. Euro,
Here.
and Mr. Bernstein.
I'm thinking about it here.
Okay. So we have everybody here. We do not have meeting minutes for consideration or resolutions. There is no planning board business this evening.
Mr. Chair, can I just bring up something in terms of business?
Certainly.
So I just want to see if I could get an acknowledgement or reply. I sent an email this week regarding CP East Brunswick, which we saw last week, that we get that updated policy on the Migratory Bird Act that their council raised in terms of the new policy that she was reading. So I just want an acknowledgement that Mr. Bernstein's office or Mr. Maskey's office is going to review it and or send it to the Environmental Commission for review before they come up for their next meeting, I believe in March.
Yeah, we'll follow up on it.
David, make sure I have a copy, and I would probably suggest we send it on to the Environmental Commission
Right.
if it hasn't been done already.
Thank you.
Okay, thank you. Any other items from the board? Okay. Next is business from the floor. This is for matters that are not on the agenda. So if there's anyone in the audience that would like to address the planning board for items that are not on the agenda, if you're in the Zoom meeting, please click on the virtual hand or press *9 if you're dialing in via phone.
Earl, I see none.
I
So
do not
Chairman,
see
you can
any.
proceed.
Okay. Let's see, moving on.
Oh, Hey, Carl,
I have a
a
late
hand,
one.
a hand went up.
I see. Okay.
All right.
Yep.
Please state your name and address for the record, spelling your last name, please.
Maria Janusic, Janucik. Regarding ordinance 2019.
Excuse me, your address, please.
That's the ordinance that amends the I3 light industrial zone. to
Excuse me, Ms. Janusek, could you state your address for the record, please?
Whatever district, inclusionary district. I had asked
Ms. Janusek, we need your address.
Planning Director, Mr. Maskey, for the records that show when that ordinance was filed with the Somerset County Planning Board. What I received via email is a document that has no signature and pretty much has no information. And one of the dates does not jive with what's on the ordinance. So when was this ordinance filed with the Somerset County Planning Board? Because this ordinance is totally important to this application.
Okay.
Excuse me, Ms. Go
Janusek,
ahead, Carl.
Two things.
I
One,
can't hear anyone. Hello?
we need your address.
Hello, I can't hear anyone.
Please state your address.
Mr. Sirachi?
Yep, we're here.
Something must be wrong with her audio, Carl, because she's not hearing us. I guess we could come back later.
Yeah, because it sounded like it was something related for the application. So we will.
Hello?
Can you hear us, Ms. Janusek? You just went on mute. Okay. All right, we'll come back if
Yeah, she's obviously not hearing us.
correct. And it sounded, again, it was something related to the application.
Sure.
So again, just one last time for anyone in the audience for matters not on the agenda, please raise your hand or press *9.
I can't hear what they're saying.
So maybe the headphones. Give me the headphones.
Let's give her 1 second, Carl. She might be getting headphones. Ms. Janusek, are you there?
This is.
Ms. Janusek, can you hear us? All right, Carl, I can mute her and promote her back down and make her
Yep.
raise her hand again.
Yep, please do.
Okay. All right, you're all set to continue then.
All right, so it doesn't appear there are any others from the audience. So we'll move on. Again, no considerations of ordinances, so we're moving on to this evening's application, which is Campus Associates LLC, otherwise known as Weiss, file 20-PB-13 MSP. This application is a hearing that's being continued from January 14th of this year without further notice. So I'm going to just turn it over to Counselor.
For the record, thank you, Mark Policastro. How's my audio? Can everyone hear me?
Yep, can you hear us?
Excellent. Thank you for having us back. We have one witness, Tom Affenord. Now, Mr. Bernstein, it was my understanding that the special master may also be making a statement this evening.
The special master, Mr. Chairman, has indicated to me that she would like the opportunity to come before the board and make a statement. It is up to the board whether they want to allow for such, and if so, when in the proceedings.
Okay, well, I don't know if she's planning on staying the entire evening, but I would be fine for her to make her statement now.
I think she's staying normally because she stayed through every other one, so why not this one? But on the screen, ladies and gentlemen, for those who do not know, is Elizabeth McManus. She is the special court master appointed by the Honorable Thomas Miller, slamming judge for Superior Court, as the special court master regarding the Townships Affordable Housing Declaratory Judgment Action. Ms. McManus, the floor is yours.
Thank you, Mr. Bernstein.
Eric, do you want me to swear in?
Yeah, why not? We'll swear her in.
Okay.
Ask her a whole bunch of things we haven't asked her yet and get her admitted on under oath.
Do you swear any testimony you give tonight is going to be the truth, the whole truth, and nothing but the truth?
I do.
And for the record, could you state and spell your name, please?
It's Elizabeth McManus, McManus.
Thank you.
Ms. McManus, as long as you have been sworn in, this is not really testimony per se. For the purposes of the record, and for those who have not had interactions with you, could you please indicate your qualifications and licensure and employment?
Sure. So first, I'm a principal at Kyle McManus Associates. We're a planning firm here in New Jersey. And my education, my experience, my experience stems back to 2001. I've been working with municipalities, New Jersey municipalities in land use since then. I have a undergraduate degree and a graduate degree from Rutgers University in environmental policy and city and regional planning, respectively. I'm a licensed planner in New Jersey, meaning I hold my NJ professional planning license. I'm also licensed nationally, meaning I'm a member of the American Institute of Certified Planners. While I said I've been working with municipalities since 2001, that's certainly true. I've spent most of my time working for municipalities, serving as municipal planner or board planner. And I also do some private work, but since 2015, particularly, I've also begun serving as an appointed special master in Mount Laurel cases, such as, but certainly not limited to, Hillsborough. I'm the special master in about 40 cases, and that came to be because of my expertise, certainly in municipal planning, but also in affordable housing, since I've authored a few dozen housing plans for communities across the state.
Thank you.
Okay. So first, thank you very much, Mr. Chairman, and to the board for giving me, I hope, just a few minutes to talk about a couple of things. I see that this is a really controversial application in Hillsborough, and I thought that perhaps some comments from me could be about the process, could be helpful to the board, to the public, and also to the applicant. But what I'm not going to do this evening is comment on the merits of any relief of any specific aspect of the application. And I simply just don't think that's the proper role for me as the special master. And before I talk a little bit about this process, I just wanted to remind everybody, to the extent that folks may not know, that the site has a long history in the community. but most recently, the most recent history began in 2015. That was when the township started its Mount Laurel, its affordable housing litigation. Subsequent to that, Campus Associates was granted intervention in the township's case. As part of that, the municipality, Hillsborough, was obligated to mediate with Campus and Associates, and they did that. They met or had a telephone discussion no less than 5 times. And during these mediations, both parties reviewed a concept plan, discussed ordinance provisions, and many other settlement terms. And those mediations were fruitful because they led to a settlement agreement that's dated May 15th, 2020. And that's, of course, between Hillsborough Township and Campus Associates.
19.
19, sorry about that. Thank you. The settlement agreement includes a concept plan, which is substantially similar to the site plan before the board tonight. It also included an ordinance that's consistent with the zoning for the site and included many other terms about the roles and responsibilities of Campus and Hillsborough. That settlement agreement was subject to a fairness hearing on August 28th, 2019. And that settlement agreement was then approved by the court via an order dated September 13th, 2019. And so just like other settlement agreements in Hillsborough and elsewhere, the purpose of this settlement agreement was to first simply resolve the litigation between Campus Associates and Hillsborough. But secondly, it was to ensure the construction of the development and to see that it was consistent with the concept plan attached to that settlement agreement. The settlement agreement had also established some other terms such as timing for ordinance adoption, cooperation on this site plan approval, process to facilitate development of the property, and several other terms that are specific to affordable housing and essentially are intended to ensure the township gets affordable housing credit for the affordable units that will be built on this site. The other aspect of the township's litigation that's important to understand is its settlement with Fair Share Housing Center, and that was executed on March 27th, 2020. And that too was approved by the court and subject to a fairness order also issued by Judge Miller. That settlement agreement is structured differently and has a bit of a different purpose, but principally what it does is it identifies the municipality's affordable housing obligation and how it will be satisfied. And importantly, that satisfaction includes the 23 affordable units from this site, from the Campus Associates site. And so now that the township got through the settlement process, now the planning board, of course, is faced with the site plan approval for this application. And I wanted to speak tonight just to ensure that everybody understand what the board's potential actions on this application mean in the context of the affordable housing litigation. So first and foremost, site plan approval of the project means that the township will be in compliance with the settlement agreement with Campus and the settlement agreement with Fair Share Housing Center. This means that the township will be on track to receive court approval of its housing plan, which is forthcoming. The outcome, the approval of that is clearly what's intended by the settlement agreement. While this is true, it doesn't mean that the developer is released from doing what's necessary to obtain approval. And that's quite simply why they are here before you seeking that site plan approval and having to request that preliminary final approval as well as any relief that would be necessary. And so while the developer certainly has significant advantages with the settlement agreement, they are indeed, of course, required to request relief for anything that may be necessary and to address the necessary criteria for that relief. The alternative outcome, one of a denial, is much more complicated and it carries with it risk for the municipality. Typically, denial of a site plan application outside of this inclusionary housing or affordable housing process may result in a challenge by the developer, which can lead to one of a few outcomes, such as having it remanded back to the board, or of course, having the board's action upheld. But where we have a situation like this, inclusionary housing subject to a developer settlement agreement and subject to the Fair Share Housing Center settlement agreement, it carries with it additional risk. So first, the denial of the site plan, it would be in violation of the township settlement agreement with Campus. It would also, of course, be a violation of the township settlement agreement with Fair Share Housing Center, as the 23 units for this site are addressed in that settlement agreement. So I'm not coming this evening to suggest that I know exactly how this could play out in court. But I have some concerns based on the case law and what's occurred in other municipalities where there has been a motion to enforce a settlement agreement. And those are some of the scenarios I just wanted to review with the board so that you had full information. So certainly the court could overturn the board's denial or simply remand the application back to the board. Where that occurs, there may be certain limitations imposed on the timing and or the conduct or the operation of the site plan process. I would think intended to expedite that process, expedite the hearing process. Alternatively, the court could appoint a special hearing officer to hear essentially a remanded application. And so that means instead of remanding the application back to the planning board for consideration, the court would remand it to one person, the appointed special hearing officer, who's typically a land use attorney, to hear the application and decide. And that one person essentially takes the place of the municipal planning board. Other actions that the court could consider include assigning a Mount Laurel implementation monitor. That person oversees and reviews all applications for developments and has the power to demand changes from a developer with or without agreement from the township. And they also, in general, they have the ability to ensure implementation of the township's housing plan and their settlement agreement. It can also, I've also seen overtures about enjoining further development in the municipality, suspending land use and zoning related legislative activity, and some other actions. And of course, most alarming is it could be a loss of immunity for builder's remedy litigation. That's certainly an extreme step, but it's one that's been discussed by the courts under different circumstances. So all of these consequences are really painful for any municipality. And they're ones that I want to avoid for any town I work with, whether I'm a special master or whether I'm their municipal planner or their board planner. So I wanted to take a couple minutes on the outset of this hearing to provide this information to the board, just to help you with your decision making, in hopes that it could be helpful for this evening. So with that, these are all the comments I wanted to make, but I do want to thank the board for giving me some time.
Thank you, Ms. McManus.
Mr. Chairman, if the board has any questions of the special master.
Yep, that's what I was going to ask, if any board members wanted to ask questions, points of clarification. Okay, I do not.
That's just one question. Ms. McMaster, Mayor Lapani here. Thank you for coming on tonight. Is the application still subject to all regulatory and DEP, EPA requirements, and they must meet those regardless of the plan?
Yeah, there's no aspect of the settlement agreement that would overrule or take jurisdiction over environmental issues that are normally part of DEP's jurisdiction.
Thank you.
Ms. McManus, thank you. Just kind of to follow up on that, this is Deputy Mayor Delcourt. As it relates to that, should there be an issue that is non-compliant with either DEP or other regulatory agencies, do the same actions as sort of the end of the process still apply? Meaning, if for whatever reason the application could not move forward because either approval was granted and they couldn't meet the environmental restrictions, or we couldn't come to an understanding on that, all of the provisions that you just outlined as to the impact to the settlement agreement would still be in effect. It would just be, we still run the same risks against the settlement agreement that we would then have to go and create and renegotiate against the gap that this would create. Is that correct? And
Yeah,
that was not one
answer
particular question, so I'm sorry. But
let me try to answer your question, and if I didn't get it right, ask again, and and then we'll talk. But if your question is, if the applicant is unable to comply with outside agency standards such as DEP, or if there were DOT issue, then what would typically happen in municipal approvals is the developer is subject to those outside agency approvals after the planning board approval. If the developer is unable to obtain those outside agency approvals, that is to no fault of the municipality, or more specifically, no fault of the planning board. So I would not foresee the municipality having any negative consequences on it, imposed upon it, if the developer was unable to satisfy any outside agency approvals.
Thank you.
Yeah, and just for the clarification also, it would be state and municipal, including Hillsborough ordinances.
Oh, hold on. So thank you very much for that clarification, because I was trying to be pretty specific because I wasn't quite sure what the question was. So when I say I can't foresee any negative consequences on the municipality, what I'm referring to specifically are outside agency approvals. If the developer receives municipal approval and is subject to outside agency approvals and they're unable to obtain those for most any reason, I would foresee no consequences on the municipality. It's put simply, it's literally not the town's fault that the development can't move forward. If the development cannot move forward because of a municipal standard that can't be satisfied, or that the municipality will not grant relief for, then at that point, some of those consequences could come into play. It's going to be fact specific, certainly, but it's a very different circumstance if it's a municipal approval that can't be obtained, such as I think we're talking about site plan approval, versus an outside agency approval from DEP, DOT, et cetera, or the county.
Yeah, I mean, I guess I'm just asking in terms of, we've been through this before with some other developments where it's a condition of approval, but there's a lot of information that we have to go through tonight. And so it's like, what comes first, the chicken or the egg? I mean, where do you get to the point where, as a planner, you're not comfortable enough to say, like, as a condition of approval, because we want to see the approval, which, kind of follows suit to a lot, it has a lot of repercussions if that approval is not obtained. It's not just what I would call like a routine thing where we've seen before, where you just need an LOI. There's some more substantial work to do here, which we're going to talk about tonight. But, that's kind of a mindset that I wanted to ask your opinion on.
So I want to answer this question. I just want to remind folks, I really don't want to weigh in on the merits of the case, like any of the specific concerns folks may have, because I don't think that's proper for me. But generally speaking, because we're sort of dancing around whether it's municipal or outside agency, anything that is subject to an outside agency, I would strongly encourage the planning board to allow that agency to fulfill that role rather than the board inserting itself in that process. If something is typically approved or reviewed by, whether it's DEP or any other outside agency, I would strongly recommend that you approve an application subject to that review and approval, knowing that if the agency requires amendments to the plan, that the applicant, as long as they're substantial, the applicant will be required to come back before you for an amended approval.
And I guess what I'm saying is, can you say, the project can't begin until the approval is obtained, rather than waiting for approval? Because I don't, that's what I'm saying before what comes first, the chicken or the egg with that?
I mean, unless there's something I'm not thinking of, but typically a project can't begin until they've been able to satisfy the conditions of their resolution. And if one of those conditions is an outside agency approval, unless there's something stated in the resolution or something unique that I'm not thinking of, I don't see how a developer could continue or begin construction until they've satisfied those conditions.
Okay, thank you.
All right.
Yeah, just to continue on this.
There's a question, Mr. Bernstein.
I heard a voice, but I didn't see whose.
Yeah, I was Mr.
sorry,
Ciccarelli here.
Mr.
Thank you, Ms.
Ciccarelli.
McManus. I thought it's very helpful. While we're continuing on this what if scenario, what if an outside agency ends up requiring the site plan to be modified? And I'm just going to speculate a reduction in the units by 25, 30%, just to fulfill some requirement. I assume that trickles down through all the agreements and everything. In fact, it might not be economically feasible anymore for the applicant. So does that then, I guess that then also affects the fair housing agreement?
Yeah, so let's say there's an approval or there's an approval from an outside agency or a requirement that would suggest a reduction in the number of units on the site. Importantly, from my perspective, especially for the fair share, a reduction in the number of affordable housing units on the site. I would presume that that's going to require mediation once again with campus associates to identify what a new site plan approval could look like, a new concept plan could look like. It would also require renewed mediation with Fair Share Housing Center, presuming that that would create a gap in the municipality's ability to satisfy its third round obligation. So that mediation would entail essentially asking and having the municipality answer the question, what is the gap created and how will it be satisfied? And then at that point, the municipality would then begin this process, or rather complete the process in the sense that it would complete, I presume, a renewed site plan application from campus associates based on the outside agency approval, and would probably end up executing an amendment to its settlement agreement with Fair Share Housing Center to either scale down the site and replace it with another mechanism.
Thank you.
Mm-hmm.
Anyone else?
Any other board member? I know Mr. Policastro would like to say something before I'd like to at least let any board member at least get a first crack, if you don't mind, Mark.
Of course.
I see none, so at the moment, that doesn't preclude you. Mr. Policastro.
Beth, what happens if, hi, how are you? What happens if the town imposes an illegal condition or applies an ordinance incorrectly? What would happen then under the settlement agreement and the parameters that you described? Any ordinance or any condition?
What are the implications of applying the ordinance? Presumably the site can't be developed as intended in the concept plan?
So yeah, if the town imposes an ordinance that doesn't apply because DEP or DOT has jurisdiction, but they nonetheless, the town, this board applies an ordinance incorrectly and then therefore creates a condition that therefore would be illegal and denies based on that because it can't be built.
Okay, so all right, so the scenario you want me to address is a denial based on an ordinance, based on a condition that was improperly imposed.
Yeah, either they deny based on an ordinance that's incorrectly applied, or they approve subject to satisfaction of that condition, which that condition is erroneous because it relates to a local municipal ordinance that doesn't apply to this case.
Well, assuming the condition can't be satisfied.
Correct.
Okay, so if the condition can't be satisfied, if the application is denied, I think those are similar outcomes. If the ordinance was erroneously imposed, if it's not applicable to the site plan application, I presume and presuming the court agreed, I assume that they would have similar remedies that I imposed before, because in both of these scenarios, well, one, it's a denial of the application as I discussed, and two, it has the same effect of a denial of an application.
And that would be a violation of the settlement agreement.
Yes, it would be a violation of the settlement agreement, a violation of the Fair Share Housing Center settlement agreement as well.
Which would actually be violation, really means breach of the agreement between those parties.
Yeah. Yes.
Yeah, and that could be in any context. That could be a DOT. If they apply an ordinance where DOT, hypothetically, for example, has jurisdiction, but the town imposes their jurisdiction when really DOT, for example, has jurisdiction and then creates that condition, or DEP, because I really don't want you to get into the weeds on the obvious issue here. I think that would not be productive.
Yeah, I'm unwilling to
Essentially,
comment on the merits of that issue.
Exactly, and conceptually, you've answered the question. It's dire consequences, and it would disrupt the settlement. It would be a breach. Thanks. That's all I have for now.
If the court were to determine that.
That was my hypothetical. Yes.
Yeah, I just want.
Yes.
Have you ever seen a
Mr. Julian again?
Have you ever seen a precedent in terms of municipal law takes precedent over state law, or state law takes precedent over municipal law? How do you interpret that?
In this context, like in an affordable housing context specifically, or generally?
Or just any, what Mr. Policastro is probably referring to, environmental law.
I mean, I can cite an application in East Brunswick Township where the municipality required I was not prepared to discuss the details of this, but the municipality required the developer to obtain a new LOI where the court found that one was not required. And that was deemed to be quite problematic. And some of those remedies I discussed were imposed upon the municipality. It's a much more complicated scenario, but that is essentially what occurred.
Any other board member? Mr. Chairman, I know this is a little unorthodox, but I would suggest at this point that you entertain a motion to open to the public any questions the public has related to Ms. McManus's statements. And limit it to that.
All right. So may I have a motion to open to public?
So moved.
Second.
Sounds like Deputy Mayor Delcor seconded. All in favor?
Aye.
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 Okay,
Aye.
so for anyone that is in the audience, public audience, you can raise your hand if you're in a Zoom meeting, the virtual icon there. And if you're on the phone, *9 to be recognized. And again, there's no question specific to the application. It's only to the comments that Ms. McManus had made. Nice. I thought I saw a hand. There's a hand. Looks like Mr. Foley. Can you let him in? Okay. Ms. Foley, can you state your name and address for the record, please?
Mike Foley, 38 Garrettson Lane, Hillsborough, New Jersey.
Thank you.
Hi, Ms. McManus. Thanks for your time this evening. Two general questions. One, being that New Jersey is a home rule state, how does that apply for a local ordinance versus, say, a state law, which takes precedent? And my second question is, which approval comes first? A outside agency approval, for example, DEP, or local approval, example, planning board approval?
Okay, so your first question was, how does the two different jurisdictions work in a home rule state like New Jersey?
Correct. Yes.
Yep. So to be fair, I think it depends on exactly what topic we're referring to. In a lot of scenarios, the municipality must minimally may not regulate below or less than what the state regulates. So if we take wetlands, for example, it's an easy example. With wetland buffer areas, the state requires not less than 50 feet for any wetlands buffer. The municipality does not have the ability to reduce that to 25 feet in their town. So that's an example of where the state law takes precedence. There are other.
I'm sorry, go ahead.
I said there are other types of state laws in various agencies, including but not limited to DEP, where the municipality may go above and beyond that for its for regulation. where the state requires X, the municipality may require X plus, but it depends on exactly what regulation we're referring to. And then your other question was, which comes first? Is it the municipal approval versus the local approval? It is typical in, I don't know how to quantify, but I'm gonna say the majority of site plan applications or site plan approvals issued by municipalities across the state, that there are outside agency approvals required as part of that municipal approval. Municipalities may not hold up a developer until they receive all outside agency approvals before they decide to grant an approval. And so because of that, it's very typical for folks to read a resolution of approval saying that an application is approved subject to several conditions, one of which may be outside agency approvals.
Thank you.
Is there anyone else in the audience that would like to ask a question? I see another hand up. If you could please promote. Marianne. Okay, please state your name and address for the record, please.
Hi, I'm Marianne Soade, 142 Johansson Avenue. Good evening.
Hi there.
Hi, I'm not sure if this question is for you, but we have a major concern with the water runoff and flooding issues. That is all we're concerned about. Our objection to this development has nothing to do with affordable housing. It's about preserving our property. So who is responsible for making sure that the stormwater runoff is going to be adequate? That's not DEP. So the township is actually the one, in fact, that has to determine whether this development is going to negatively impact my neighborhood through the stormwater runoff and what's existing and what's not. Is that correct?
Yes.
Okay. Okay, that was all I had to ask. Thank you.
Okay.
Anyone else? I see Miss Gulliford. Please promote her. Hi, Susan.
Good evening. Ms. McManus, there was a lot of very technical information in there.
Susan, state your name. for the record.
Susan Gulliford, Hunt Club Road.
Thank you.
Thank you. I think I'd remember that by now. Ms. McManus, you had a lot of really technical information in there. I'm just a member of the public. I'm not a specialist in any of this stuff. If this was denied, you said it would get remanded and the court would not determine the reasonableness of the denial, but would appoint someone. I can't remember the name of what you said. They would appoint a person.
Yeah, let me clarify. And I know I did go through a lot of really technical information. So I'm sorry for members of the public that might be unfamiliar with this process, and some of that information may be unfamiliar. I'm trying not to take too much of the board's time, although I'm not sure how well that's going. But so what I talked about was what can happen when a board denies an inclusionary housing application that's subject to a settlement agreement, and what actions, I'm sorry?
Could happen.
Exactly. What could happen if that occurs? My point was not to say, so I know this is not exactly your question, but let me be clear. My point was not, should Hillsborough deny this application, these things will happen. Because one, I can't speak for the judge in that way. So I want to be very clear about that. But your question was, essentially, would the judge simply move directly to these items, or would he consider the reasonableness of the board's decision? Yes, the judge would definitely consider the reasonableness of the board's decision. The only reason why a judge would remand an application, overturn the denial, appoint the special hearing officer, which is who you were referring to, or any of the other consequences, he or she would only do that when they've made a determination that the denial was improper, that the municipality perhaps did not follow the law, or was acting in an arbitrary and capricious manner, or otherwise denied the application for improper reasons. So only if that finding was the case would I expect the judge to impose negative consequences on the municipality.
Okay, so if it's denied and remanded, the court, I know you can't say what a judge will do.
Right.
The court might uphold the township's denial.
That's the case anytime there's a challenge of a site plan application. There's, you know, just because an application is challenged doesn't mean that it will be successful. And so there's always a chance that the municipality's decision will be upheld, just like there's always a chance that the court will find in favor of the challenge of the developer.
Okay, and I have a question about township, for example, township ordinances. Talked about state level. When you get down to the township level ordinances, a simple ordinance like a sign design or something like that, something that the developer could easily do, just redesign or resize a sign, whatever it would be. They're not gonna start getting in the weeds for stuff like that, right? If it's something a developer could easily do.
I haven't seen that circumstance. I haven't seen, let me be clear. Are you talking about an approval of the application with but a concern about sign, or denial of an application? I'm not sure how to answer the question because I'm not quite sure what the scenario is that you're
Okay.
referring to.
I thought that at one point there was a question about something simple like a sign design not being upheld, that was a variance. Something that the developer could simply, you know, put more square feet in their sign or less square feet or something like that. But because it's only a township ordinance, okay, only at the state level can things like that be overturned, or could a small ordinance like that still be upheld?
So generally speaking, I think this will answer your question. Technically, a court could overturn any ordinance that a municipality adopts, no matter how consequential. If it was adopted procedurally improperly, or if it was not consistent with the municipal land use law or applicable case law. Does that answer your question, though?
Yeah, I think it kind of did. It's just a lot of technical information. Thank you.
Okay.
Anyone else from the audience? Okay. Don't see any more. So thank you, Ms. McManus.
Any other last board questions? Beth, you planning on, I assume, sticking around for the remainder of the hearing?
Yeah, I'll be here, camera off, but I'll be listening.
Okay.
Thank you.
Thank you, everybody. Thank you, gentlemen.
Okay.
Mr. Policastro.
We call Mr.
You're back.
Applewood. Our next witness is Tom Applewood.
If he will unmute him, or he will be unmuted.
Good evening.
Mr. Applewood, you've been previously sworn at the last hearing, is that correct?
That's correct.
You realize you're still under oath?
I do.
Mr. Policastro, do you mind if your witness restates for the purpose of the record his qualifications and his professional?
Happy to do that.
Okay.
I have a bachelor's degree in biology and a master's degree in biology from the undergraduate is from University of Alabama in Huntsville. The master's degree is from Ohio University. For the past 34 years, I've been employed with Eco Sciences. I'm a vice president there. My area of expertise is regulatory compliance with wetlands, threatened and endangered species, environmental impacts. I've been routinely working with regulatory agencies in New Jersey, the NJDEP primarily, but also the U.S. Fish and Wildlife Service. And I've been approved as a expert witness in environmental matters at numerous boards in New Jersey, and including Bridgewater, Berners Township, Reddington Township, etc.
You're on mute, Mr. Policastro.
Mr. Bernstein,
Yes, sir.
Satisfactory? Or is there additional questions about his qualifications?
No, I don't. I just wanted, for the purpose of the record, since I know he was on late in the evening
Great.
on the last hearing, for anybody who might not have heard his testimony
Great.
before. All yours.
That's right. So you've examined the site, is that true?
Yes,
You've reviewed the Environmental Commission letters, is that also true?
yes, it is.
How about the stream corridor ordinance? Are you familiar with that?
Yes.
In terms of existing conditions, please explain to the board the existing conditions that you did explain last time, but it's been a while. So focusing on those regulated by DEP specifically.
Okay, yeah, there are freshwater wetlands on the property, and the applicant has obtained a letter of interpretation that verifies their boundary. It also contains water features regulated under the Flood Hazard Area Control Act, including the state open water or a stream. The state open water has no wetland buffer. However, the NJDEP has confirmed via email that a 50-foot riparian zone applies to the state open water.
Okay, so I want to please repeat that last part about the email. Your audio, at least on my end, was not perfect. So with respect to the email received from the DEP.
Yeah, in terms
and
of,
also focus on the import of that, please.
In terms of the riparian zone, which is 50 feet, that riparian zone has been confirmed by email by the DEP. And that applies to the water features on the property.
So how does DEP regulate the open waters feature with respect to buffering? How does DEP see it? And how do they regulate it? With what type of buffer?
It's a 50-foot riparian zone.
Can you elaborate on that and explain, the specific DEP regulations?
Yes.
Why DEP imposes a 50-foot buffer requirement?
Yes, because there's no significant ecological components that would require imposition of a larger buffer. So the streams features, they don't drain to a category 1 water, which would require a 300-foot riparian zone. They don't drain to a trout production water or a trout maintenance water, or they don't flow through documented habitat for endangered or threatened species that are critically dependent on the regulated water for their survival, on site or within a mile downstream. Any of those 3 things would require imposition of a 150-foot buffer. So if you're not one of those things, then the 50-foot riparian zone is applied.
Now, what if you're in conflict under the ordinance and DEP's regulations, the local ordinance? Are you familiar with how this ordinance deals with that situation, where there's a conflict between what DEP would require and the purported 150-foot buffer?
Yes. One of the expressly stated purposes of the Stream Corridor Protection Ordinance is to complement the existing state, regional, and county stream corridor protection and management regulations and initiatives. Another expressly stated purpose of the Stream Corridor Protection Ordinance is that it is not intended to conflict with any applicable regulations from the New Jersey Department of Environmental Protection, the NJDEP, which shall govern. So in the event of a conflict, DEP's regulation governs.
So in this case, which would govern? The 50-foot or the 150-foot buffer, hypothetically, to the extent this even applies?
The 50-foot. The 50-foot DEP riparian zone.
Good. Understood.
As the DEP has determined that a 50-foot buffer would apply, imposition of a 150-foot buffer would not complement the existing state management regulations and initiatives, but rather it would conflict with applicable DEP regulations, which the Townships ordinance states shall govern. Not only would imposition of a 150-foot buffer be inconsistent with and contrary to NJDEP's determination that a 50-foot buffer is required, a 50-foot stream corridor buffer accomplishes the other purposes of the Stream Corridor Protection Ordinance of the township.
So you believe the ordinance does not apply to this feature, is that true?
Yes.
Hypothetically, though, is the 150-foot buffer necessary or useful in this case?
No, the ordinance speaks to the purpose of ensuring that appropriately placed development on a property will not increase danger to human, plant, or animal life, and that it represents an acceptable use of the land in relation to the hazards involved. The NJDEP is the agency that's charged with protection of these concerns, has extensive regulatory programs in place to specially protect wetlands, waters, and riparian zones, and administers those programs to limit development in sensitive areas, including stream buffers. Here, the DEP, as the agency with the expertise and charged with protection of the natural resources, has identified that the appropriate size buffer for protection of the water body and the surrounding areas in the context of the contemplated use is 50 feet. Accordingly, a 50-foot buffer is sufficient for protection of human life and natural resources.
And how has this ordinance been applied by the township and by this board historically? Has it been applied in these cases? In
the case where the drainage area is less than 50 acres?
Yeah, so just really focus in on the 50 acres and explain and provide your opinion on the 50-acre requirement, why that's relevant to the board's determination.
Well, you have to have some guideline as to where the ordinance applies. And the guidelines that has been recognized in Hillsborough is a 50-acre drainage area. So if the drainage area to the stream feature is greater than 50 acres, the stream corridor ordinance would apply. If it's less than 50 acres, the stream corridor ordinance has not applied.
Historically?
Yes.
Okay. Before we conclude, do you have anything else that you want to add along those lines? About anything? Because I have just one more question.
No, I don't think so.
So I don't know if it's appropriate, but I'd really, to be efficient, Mr. Bernstein, I'd like to ask Mr. Euro, who has, it goes to the last question. You know, Mr. Euro provided his comments, not testimony, that he agreed with Mr. Ford with respect to the historic application of the ordinance. So look, we are in a COA stance. We're trying to be efficient. We understand that we have a lot of members of the public that are uniquely interested, and we have been, we think, responsive to their questions. But could we get Mr. Euro to weigh in on this? Because Mr. Euro did give his comments on this precise issue. And we were, as you can see, are trying to really utilize some laser focus here and not beat around the bush, because we don't believe, and we've testified, that this ordinance just simply does not apply and DEP has jurisdiction. And we'd like to hear from Mr. Euro if that's possible. Procedurally, I don't want to disrupt how you want to proceed, Mr. Chairman, Mr. Bernstein, but I think it would make sense from my own perspective.
Your thoughts, Mr. Chairman?
I have no problems. So let Mr. Euro comment.
Thank you, Mr. Chair. Mr. Policastro, just based on the testimony that was provided, just the one thing I'd like to clarify is my involvement with Hillsborough has only been for the last 2 years. So I can't speak historically over any time longer than that on how the borough has applied their stream corridor ordinance. What I think I did agree with Mr. Ford is the classification of that feature. And it was my opinion that I would classify it as a drainage feature, a swale, and that I would not necessarily classify it as a stream to that extent.
Fair enough.
So with that taken, that would then sort of go with the DEP's determination that it's a state open water with a 50-foot buffer. And if it is not classified as a stream, then the 150-foot stream corridor buffer would not be applicable.
Excellent. I appreciate the comments. Mr. Chairman, that's all we have for this witness.
Okay.
For Mr. Atherton, that is.
I'm just going to open up to the board members.
Okay, Mr. Chair. I guess I could I could go. So Tom, can I just call you Tom? Because I'll butcher your last name over and over again if I don't, all right?
If I can call you Neil.
You certainly can, or even worse if you want. So the letter that the Environmental Commission, you received the January 26th letter, right? Not the previous one.
Yes.
So we're talking about the January 26th. So just for the record too, I was one of the people that did go out there. I think it was last week or the week before. So I did walk the site between the last meeting and this meeting.
Okay.
And you kind of broke up with what you said, the email you got from the DEP. I don't know if I heard you clearly, but what we saw and what we interpreted is that we saw a stream there and we saw enough water that we would classify it as a stream. And the LOI itself does not classify it, does not use that regulation to classify streams. They use it to classify wetlands. And the water feature on there is definitely not a drainage ditch. You can see by the pictures, it looks like a stream. And it also has been classified as a stream previously on some mapping, some historical mapping on the Dukes Brook tributary, the RW2. I mean, there's been historical technical information that it has been classified as that before, which we stated in our first point. I think it comes down to also the classification of a river is really determined under the Flood Hazard Control Act. And that's what we were talking about last time. So when you guys originally went to the DEP to submit that permit, for whatever reason, I don't know, but that permit you pulled back. Now, I don't know why you pulled it back, because that's, in our opinion, that would be the real determination on how to classify if that waterway is a river or not under the not under Wetlands Protection Act, but under the Flood Hazard Control Act. So I was there, we saw that. It's our determination that the DEP, you should submit to DEP that permit again under the Flood Hazard Control Act and really get a determination whether that is a river or not a river. And when we were out there, and you can see by the pictures, that was not a drainage ditch, in my opinion, for whatever it's worth. And the other people who walked the site didn't think so either. And the other people that walked the site were sworn in last time, probably have a lot better technically than I am in terms of waterways. I mean, I've been in the environmental business for probably 30, 40 years, but they are specialists in similar things that you are in terms of water and permitting and that type of thing.
Regardless of what I thought originally about the feature, Neil, the NJDEP, and I hope you can hear me.
Yeah.
When they were reviewing the application, they told us, they confirmed via an email that they were going to regulate that feature under the Flood Hazard Area Control Act as a stream, and it would have a 50-foot riparian zone. So that is what we are showing on the plans, and that's what we've got.
But did you get the permit for that?
Well, we're going to get the permit, and so we're going to comply with state and any national requirements that there are. So this board, respectfully, doesn't have jurisdiction to tell us what we have to do with the state of New Jersey or nationally or with the EPA.
Mr. Chair, Bob Euro.
Go ahead, Bob.
Mr. Uffenord, if you can just explain, to follow up on some of Mr. Julian's questions, one initial application was submitted to the DEP for flood hazard determination, LOI, et cetera, in July. From testimony, it appears to have been withdrawn. Can you indicate as to why it was withdrawn? When do you anticipate reapplying or resubmitting your information? And what is the time frame that you anticipate receiving any kind of approvals?
We hope to resubmit the application shortly. The application was a combined freshwater wetlands application and flood hazard area application. The flood hazard area application portion was withdrawn. The freshwater wetlands application portion is still active. The flood hazard area application was withdrawn because, as you know, there's several ways that one can calculate the floodplain, the extent of the floodplain. And the NJDEP in their review indicated that they thought that we should use a different method than we had applied with. So we had to withdraw the application because, as you know, those applications run on a clock, a 90-day clock. So we have to recalculate the floodplain based on a different method, and we're close to being ready to resubmit that.
Okay, and as a follow-up, you indicated that on your initial application, you received an email from the DEP indicating they're taking jurisdiction of the waterway, ditch, stream, whatever in question that runs diagonally through the property, and they classified it as state open waters. Do you anticipate that with the resubmission of your FHA with the new calculations for your floodplain, do you anticipate that determination changing? And if so, could they be possibly imposing greater buffer requirements buffer requirements?
No, I don't anticipate that changing.
Bruce is gonna say no. Oh, God.
Okay, but still, it's still going to be under the jurisdiction of the DEP. They still need to render their decision.
Yes.
Thank you.
I just have a quick follow-up question on earlier where it started, stating that you got an email from the DEP. Who from DEP authored that email?
The environmental reviewer, Mark Harris.
Okay.
And Ms. Raffenard, is that part of your submission, your letter submission dated
13th.
January 13th?
Yes, it is.
Thank you. It's January 13th, 2021.
Yeah, yes, it is.
Any other board members?
Well, I would definitely think that, you know, an application as important as this should definitely wait for a jurisdiction from the DEP under the Flood Hazard Control Act, deeming that a river or not a river. So that would be my opinion on that. And then going into the stormwater issues.
Can I ask a question? So is that the board's customary practice to have the outside agency approvals procured before you decide on the case before the board? Is that your practice?
No.
Especially in a COA proceeding, because I know what Judge Miller was saying.
Mark, the answer to the question is no. It is not the historical. Let's not try to flood the record, quote unquote.
No, I'm just not to the contrary. The suggestion was just made by a board member.
A suggestion was made by a board member that the board consider a condition which would require your client to get approvals pre-board action.
So that is
the answer to the question is, it is not my recollection in the 20 years I've been the board attorney that the board has done so. Doesn't mean they can't, but it has not been the history.
Especially in a COA proceeding, Mr. Bernstein, I think that would be.
I will characterize generically. It has not been an issue one way or the other. And whether it's a affordable housing proceeding or not, the board has the right to change positions as it so chooses, if that's what the board ultimately decides based on what is before it this evening and the previous evenings, assuming a decision is made this evening.
So there were two more topics that I just wanted to talk about. One is the stormwater drainage, and the other would be a phase 1 recommendation based on what we saw out there with a hill. But the discussion with the stormwater was that the stormwater calculations were based on a hypothetical situation of water draining into a pipe that it doesn't drain into now. So based on a hypothetical scenario, we felt that there should be a lot more kind of technical review based on a realistic scenario rather than this hypothetical scenario, because the water right now is not draining into that pipe from that property for whatever reason, you know, whose ever fault it is, but it's just not. So if you're going to put the additional stormwater into a pipe that's not collecting any stormwater now, like I said, it's all kind of hypothetical. So we thought there should be a more robust review of that.
Yes.
And then I don't know if you want to comment on that, and then I'll go on to the third thing, which is the phase 1.
That's really the stormwater details are not my area.
It's not, that question is not for this witness. It would be for Mr. Ford.
By the way, is Mr. Ford here this evening?
I do not see him.
Don't see him yet.
So a little worried, but we were expecting him to be here. So we reached out to him, Mr. Chairman.
Leaving aside whether the witness can or cannot answer the question, Mr. Policastro, for your consideration, I'm not asking for an answer. One of the issues that is required, obviously, of this application, irrespective of what kind of application it is that you are not that the applicant is not supposed to be adding to, and if anything, trying to reduce the stormwater running off from this property, irrespective of what kind of application it would be. The hypothetical question is, would it not make sense for all parties involved, both the municipality, the board, and your client, to have a more accurate set of figures relative to runoff from the site at its current situation, as we will potentially ultimately face questions raised by neighbors, etc., that in reality, your project, in fact, did not only not reduce, but in fact increased. As I said, it's a rhetorical question at the moment.
We listen. Sorry, Eric.
No, go ahead, Mark.
I do need Mr. Ford to respond to that. I know it was a hypothetical, but it was.
Well, I
didn't like the way that the hypothetical, those facts.
Well, it was hypothetical, rhetorical, and necessary, because I think one of the issues that I think, and Mr. Julian on behalf of the Environmental Commission is, I believe, attempting to place on the record, and you've heard the testimony of some of the, I won't say the testimony / comments of some of the public, is the concern that the situation is already bad and that your client may make it worse. And I think for everybody's involvement, especially under the new stormwater regulations, that I think that's a situation your client is going, and the township / board has to look at, as it relates to knowing exactly what the current situation is, because the next time something happens, it's going to be, well, you people didn't know what it was, and then we're all going to be in the same proverbial boat. So yeah, you're probably going to need Mr. Ford, but I'm just advising. I think that's the comment of the Environmental Commission. I think that's the comment of Mr. Julian on behalf of them. I think that's been comments made by members of the board throughout this proceeding. And I think it's also been comments of the neighbors that we need more accurate and complete numbers and scenarios as to what is currently in existence, so that we have an idea to measure going forward.
Yeah, and we're prepared to give you direct answers to those direct questions.
Thank you. Mr. Julian, I didn't mean to intrude.
Thank you for the clarification. And then, so there was another issue, which is on the second page of the letter, which refers to a mound of soil on the property, which when we walked it the other day, we walked to the mound and identified it. So we just don't, there was a question that was brought up from a resident relative to that mound, and they asked if it was from a prior site preparation or a possible fill or material brought onto the site. It was mentioned that the mound of soil may have potential to alter the drainage of the site. So without the knowledge of the original soil pile, we were asking the applicant to provide a phase 1 of the site, including the historical area photographs to better understand where the soil piles were located on site and the origins of that pile. So that was something I saw when I went out there as well.
Yeah, so we don't believe we need a full phase 1, but we will certainly comply with DEP regulations if there are regulations that require characterization of the soil. We don't believe there's been a discharge under the Spill Act or any other statute or ordinance, but we'll certainly comply with that provision. And if we have to characterize it, we will certainly do that. And we do that routinely in all of our projects. And we'll be transparent about it.
That's all I have, Mr. Chair.
Okay, thank you. Just before we proceed, I'm just going to ask everyone if to be sure that you're on mute if you've got some background noise, because we've been hearing some background noise. Not sure where it's coming from. Okay, any other board members that would like to question the testimony thus far? Okay. So with that, I think I will go to the public. If anyone would like to question this witness on his testimony, please raise your virtual hand or press *9 if you're dialing in by phone. And I seem to see Nancy. We could promote her. And Nancy, please state your name first and last and your address for the record.
Nancy Guancione, 58 Campbell Road.
Ma'am, would you spell your last name for the record?
Guancione.
Thank you.
Good Italian name.
It's amazing how people can butcher any name, but thank you.
For the witness, you did talk about, you mentioned wildlife as being one of your areas, although you did not speak to it. I do have a question in regard to wildlife, so I'm not sure if I could pose that now.
Yes.
I have a major concern due to the loss of the woodlands and the wildlife and the habitats. And I know there was mention in one of the exhibits about it being a foraging habitat for the great blue heron and the American kestrel. So I'm wondering if that was looked into or if there's any latest in that regard.
Yeah, the great blue heron, not a threatened and endangered species. As you probably know, if you're interested in birds, they forage along water bodies and streams, rivers, ponds, and habitat for the great blue heron is mapped on the property. The project is going to have, some very limited wetland impact, but the vast majority of the wetlands on the property, which are substantial, are going to remain. They're going to be undisturbed. They're going to still be habitat for great blue heron to the extent great blue heron uses the property. The American kestrel, which is a state threatened species, is not mapped on this property. It's mapped on the Duke Farms property across Route 206. And the American kestrel is a small hawk that uses habitats that are open fields with scattered large trees, especially trees that have snags and holes for nesting. It's a cavity nesting bird. There really is no appropriate habitat for American kestrel on this property. And that's why it's not mapped for American kestrel. So the project, again, is not going to have any impact on American kestrel or American kestrel's habitat.
Yeah, a lot of trees coming down though, which is very sad. Okay, all right, thank you.
You're welcome.
Thank you. Is there anyone else in the audience? I see a hand up. Please promote. Okay, state your name and address for the record, please.
First name John, last name Tutunjan, T-U-T-U-N-J-I-A-N, address 150 Johansson Ave. Tom, I don't, are you considering it then a stream or a swale? What's your determination on what that?
It's a stream.
It is a stream.
The DP has told us it's a stream.
So if, in your expertise, if it is a stream and obviously a parking lot and a roadway that's going to be placed over that stream, the salt runoff from the parking lot in the wintertime and oil and whatever else from vehicles, how is that at all going to affect the habitat?
First of all, the stream and its associated riparian zone is not going to be paved over. It's not going to be disturbed at all. So
how?
I'm not sure what your
Oh,
question
so the road that goes in, that's going to go over that body of water. I guess it's going to go under, because right now you're building the road, the entrance to get in that going over. There's going to have to be something built underneath for that to flow, correct?
The road runoff will be directed into the stormwater management system. So it isn't going to just discharge into the wetlands. It's got to be treated first to improve water quality and also be detained. So, salt and things like that are not going to be discharging directly into the wetlands until they've been treated.
Yeah, because I'm not clear on how that's going to happen, because I'm looking at this body of water that's cutting across that the piece of land that you're proposing to build on, and the road has to go over that body of water.
No, it does go over it.
Okay, so we have now 20 inches of snow. I don't understand how with salt and oil and how it's not going to be thrown into that stream. How is that not going to happen?
Well, the road is curved, so the runoff doesn't just run straight off the road. And it's curved and it's collected into the stormwater management system.
So if the road is being built through over the stream, it's almost impossible to tell me that there's not going to be any kind of runoff into that stream. And my question is,
Bob Euro, just for clarification, if we're looking at the proposed site plan, the proposed driveway is going to cross over the top of an existing 18-inch corrugated metal pipe. The road is not transitioning over any of that ditch, stream, waterway, et cetera, that we've been discussing. The roadway will be curbed. Not to testify for Mr. Ford, but just to try to answer the gentleman's question. There is an existing 18-inch pipe that the roadway will go over the top of. All of the runoff will be contained within the pavement area, collected by the proposed drainage system, deposited into the underground detention system, and then through a mechanical treatment device for water quality purposes. That is the design that's proposed before the board this evening. Thank you.
Thank you.
okay. So your testimony is then with the new proposed parking lot and buildings that you see that none of the, I guess, oil or any from vehicles or salt will penetrate or touch that stream. That's the way we're looking at it.
I'm a biologist. I don't like to use words none or always, but the system is designed so that all of those kinds of things are collected and treated.
Okay. So let's say somehow there's a flaw, which we all know nothing's perfect. My question to you is if salt, oil, gas, or any other contaminant, if you're building within 50 feet or close to 50 feet to this stream, gets into the stream, how would that affect the habitat in the local area of the wetlands, if at all?
Well, I really don't think that is going to happen to any degree that would have an effect.
Yeah, and I think it's beyond the scope of what he testified to.
I'm
Okay.
just going to add in there that perhaps we'll park that question from when Mr. Ford arrives.
Okay, thank you.
Thank you. Okay, I believe we have Mary Ann with her hand up. So if we can promote her.
Hi, Mary Ann Soade, 142 Johansson Avenue. There's so much information tonight. Excuse me. All of the runoff from this development is supposed to go into the stormwater system, which is not verified. So that's a problem. I don't understand how the board can possibly make a decision on this project and development when we don't have accurate facts of how the stormwater is going to be diverted. The inlets have been recently dug up. So obviously they have not been working, and that was what you were going to tie into. All the water all the stormwater runoff has been going to the stream, the Dukes Brook tributary, and running down the other state open waterway, the swale that collects all the runoff that I maintain on my property. So it's all natural, course of water is just running, and the stormwater system is not working. We have established that. The board it's impossible for you to make a decision on this application until we know if this stormwater system can be fixed.
Mr. Chairman, are we on the comment section or are we on the Q&A section?
You'd love to cut me off. I'm making a statement. I'm allowed to. I'm a member of the public. I am a neighbor of your property.
Mr. Wadey, no one is cutting you off. However, there is a process, and partially I'd say in large measure for a record. If you have a question of the witness, you're more than welcome to answer. There will come a point in time, sometime during this hearing, where you will be allowed, along with your neighbors and friends, to make comments on the application as a whole and present anything you want to the board. But for the purposes of keeping the record as clean as possible, this period of time is questions of the witness submitted by the applicant.
Okay, I am prepared to ask a question. Thank you. With regard to the DEP applications, I would like to know why they were specifically withdrawn. You had kind of answered that.
No, Mr. Chairman, listen, that question has been asked by.
Yeah, Mr. Policastro, she would like to hear.
Ask again, but the judge, listen, if we have to go to the judge and show this transcript to the judge where the same question is asked 3 or 4 times, the settlement agreement does not contemplate that.
I'm elaborating on a question that was answered. Let me ask my question. It is my turn.
Contemplates cooperation by this board, and by letting someone ask the same question that's already been asked 4 times, the judge will look at the settlement agreement.
This is not the same question, Mr. Policastro. Back down. I'm tired of you cutting me off.
Mr.
I am asking a question. The application was withdrawn from the DEP. You had said, or someone had said, that they said to use a different method to calculate. What does that mean? That is my question.
That question was already answered.
No, it was not.
Actually, Mr. Policastro, let's talk about it. In the time it's taken to have this discussion, your witness probably could have answered the question. I believe he did not answer the issue of what a different form of calculation DEP had asked. If you can answer that question, sir, can you?
It's just a different method of calculating the floodplain.
Okay.
That's the answer.
That's not very specific, is it? So is it a different method of calculation that meets your plan, or that will be better for the environment? I don't know. What is the standard for that that reasoning or calculation? I don't see that being a valid answer at all.
Let's leave aside the characterizations. Can the witness illuminate his answer any further?
I don't think so. There's.
Okay.
So you were told to use another method in calculating, but you don't know what that is. Is that correct?
Well, I'm not the engineer. The engineer makes those calculations.
Okay, so
Uses that method.
all right, so it sounds like we need to park this question too until Mr. Ford shows up. So do we know if Mr. Ford's showing up tonight?
I don't know. We cannot locate him. So again, I'm hoping he's okay.
All right, so I'm just gonna just to remind the public again, the current witness is biologist, I'll call it, environmentalist, specialist, not an engineer. And when Mr. Ford shows up, I am sure we will promote him very quickly to answer some of these engineering questions.
Okay, I just have one more question for Mr. Offenord. He had said that the DEP had sent him an email, which I saw a copy of in the application, that there was a 50-foot buffer required for this waterway. I had submitted over requests that I have not received answers to, and submitted personal emails to Mr. Mark Harris at the NJDEP, which I have not received an answer to this question. Has he or his team actually physically walked this property? Or do they just rely on the information you provided, which we've already kind of established? You've downgraded this waterway in your application. And so therefore, I don't know if they had the proper information to make that determination on the buffer required for this waterway.
Let's, for the purpose of the record, indicate that the requests made, ma'am, were to the New Jersey State Department of Environmental Protection?
Correct.
Okay. We obviously have no knowledge whether or not DEP intends to answer or not, or how they do. And since it's not before this board, I think we can indicate that you've made that request, but there's nothing before the board for consideration at this time.
Okay, no problem.
Ms. Wade, I just checked the letter of interpretation that we received in July of 2017. Just to make sure my memory was correct, Mark Harris was the reviewer on that application and did conduct a site inspection.
And that happened when?
In 2017.
What month?
I don't know.
It's relevant because this is an intermittent stream. It is dry in the height of the summer, and it is filled with water and filtering water from fall to spring. So if he was there in July or August, the site may have appeared, or the stream, the feature may have appeared to be insignificant and of minimal significance. But for the remainder of the entire year, it is filled with water, and so is the swell behind my house.
I'm not sure there's a question, Mr. Chairman, respectfully. I really.
I was.
My question was, when was he there?
There's a lot of testimony.
I don't know.
Okay. Okay. That's fair enough.
Right.
He was there. He was there.
Yeah, she was just trying to make a point that it's very important to know when he walked that.
For the purposes of the record, for board members, in the absence of information before you, I would ask you not to speculate on when Mr. Harris did or did not walk it, what conditions he found, and what was out there at the time. In the absence of something before you to indicate what occurred or didn't occur. If something comes before you and this application is still pending, that obviously is a different issue.
Mr. Chairman, if I may, the letter attached, dated July 2017, indicates that site inspections were made by the Division on September 15th, 2016, November 7th, 2016, and January 13th, 2017.
Okay. Well, thank you, Mr. Chicarelli. I see that here now.
Okay.
So he was there not only one time, but 3 times, and including in January
Great, thank you.
What year?
2017.
Okay.
Okay, before I go to the next hand, I'm just going to ask our court reporter. Mike, we're about, an hour and a half into this. Do you need a break?
Yeah, if we could take maybe 7 or 8 minutes, I think that'd be great.
All right, so you got the same clock I do. It's 9:12, so we'll recess until 9:20.
Thank you.
Thank you.
Chairman Carl, are you still there?
I'm still here.
I just want to let you know, Fred's back and Jim, I relieved Jim, so I just want to let you know.
Okay, yeah, I see. Bill.
All right, thank you.
Hey, Fred, can you please remute anyone that's not promoted? There's way too much background noise.
Yes, I'll make sure we mute everybody that's not, on the panelist. Sure will do. Thanks, Frank.
Thank you.
Ms. Cafone, are you there? Eric, everything ran okay on my absence?
Who are you? We haven't had camera, video, or anything in the last hour.
Well, here I am. I'm back. Jim was able to get through some of the public stuff, no problems.
Jim, everybody was fine.
Excellent. Thank you. I just
almost to the point where no one even knew you were missing.
Well, that's easy, but
I did. I knew he was gone because he didn't. I wasn't promoted so quickly.
As soon as I got in, I saw you there. I kind of cracked up laughing. That's why I promoted you right away.
I'm like, Fred must be back.
He's sending you a message there, Kurt.
I won't read too much into that, Eric.
By the way, is Mr. Ford anywhere to be seen?
He is not. That I have been checking religiously, and I don't see him. Unless he's using an alias, I don't see him.
He's not. We do not believe he will be here tonight.
Thank you, Mr. Polikash. Eric, I wasn't sure. Was Miss Sawady done with this, or is it still her turn to speak?
I believe she's done
for this witness. Okay. Well, she will certainly be able to raise her hand again if not.
Okay, looks like it's 9:20, so let's reconvene.
I assume we'll have a roll call.
Yes. Good.
Mr. Emick.
Here.
Mr. Ciccarelli.
Here.
Mr. Santa Ramita.
Here.
Mr. Peason. We'll come back to Bob. Deputy Mayor Delcourt.
Here.
Mayor Lapani. I heard you.
It's an interesting voice, Sean.
That's not my dog. That's somebody else's dog.
Mine.
It's Rob's dog.
Vice Chair Julian.
Here.
And Chair Sirachi.
Here.
And Mr. Peason.
Here.
Mr. Kinsler, you're here. Mr. Maskey.
Dave, you're on mute.
I just sent him a message to unmute.
Thanks. Mr. Euro.
Here.
Mr. Bernstein.
Mm.
I was waiting until you were drinking.
Man, a few words.
I wish.
On a super sippy.
All right.
Mr. Maskey's the only one I don't see.
All right. Are we back on the record, at least at the moment?
Yes.
Okay. We are still under public questioning. of Mr. Policastro's witness. Is there anyone else who wishes to be heard as to the testimony of the witness?
Yes, we do have.
Or his responses to inquiries during his appearance?
Yes, we have a couple.
Mr. Abrupta is next. His hand's been raised since almost 9 o'clock, so.
All right, Mr. Abrupta, if you could state your name and address for the record.
Spell your last name, please.
Spelling your last name, please. Thank you.
Christopher Abrupta, Obropta. I live at 605 Cornwall Court in Hillsborough.
Mr. Abrupta, before you say anything, is Mr. Lombardozzi with us?
I am, sorry.
Okay, just want to make sure. Okay, sorry.
I'm also a member of the Environmental Commission, so I just want to fully disclose that. And I actually walked the site with some of the Environmental Commission members. So I guess my question to Thomas is, it seems he's in agreement that this is a stream, as DEP has pointed out. Is that correct, Thomas?
That's correct.
And if it is a stream, then our stream corridor ordinance should apply. Our corridor ordinance has 5 purposes, and you've talked about actually 2 of them earlier. So the one that you've mentioned was the purpose of our ordinances. One of the purposes is to complement the existing state, regional, county stream corridor protection and management regulations and initiatives. Couldn't it be argued that if the state is recommending a 50-foot buffer, that by increasing the buffer by 100 feet, we would be complementing the state's buffer and efforts to protect that stream?
Can you ask that again, please?
So if the state is recommending a 50-foot buffer, couldn't it be argued that we were complementing the state's recommendation by increasing that buffer by 100 feet to 150 feet to further protect the waterway?
No, I think you're conflicting with that determination.
So complementing the existing state's requirements, would it mean increasing the buffer? There is another purpose of this that you noted, that this is not intended to conflict with DEP, with any applicable regulations from New Jersey Department of Environmental Protection, which shall govern. And you took that to mean that DEP recommended 50 feet, so we can't conflict with 150 feet. Couldn't that be taken to mean that DEP, if DEP recommended 300 feet, we couldn't conflict by recommending 150 feet? Actually, Elizabeth McManus suggested that and testified that the town cannot be less stringent than New Jersey DEP. So couldn't that purpose be put in the ordinance because of just that? We as a town did not want to be less stringent than DEP, and that word, meaning not intended to conflict, would mean that the buffer that we're recommending of 150 feet cannot be smaller than New Jersey DEP's recommendation. So I guess my question to you is that, these purposes can be read different ways depending on which side of the table you're sitting on and trying to get the development approved. So my argument here would be that, and I'm not trying to testify, but if the town doesn't have a stream corridor ordinance that was designed to further protect our waterways, because we as a township believe our waterways are important to the town, and therefore we passed an ordinance that requires all streams to have a 150-foot buffer, that even if New Jersey DEP recommends a 50-foot buffer, we can complement that by increasing that to 150 feet, provided we don't go less than 50 feet, which is what New Jersey DEP recommended, so we don't conflict with what the recommendation is.
Well, you really, sorry, you're before you answer, Tom, he was really asking a legal question, and it goes to preemption as to whether DEP has jurisdiction and which entity is in control. Is it the local ordinance or is it the DEP regulation? It's a legal.
Well, that's for the lawyers to decide, right? Isn't that the lawyers to decide?
No, it's also for DEP.
It is a home rule state, right? I mean, don't we have control over our land use in New Jersey? I mean, we as a town have designated that land use to be
well, if there's
so why couldn't we actually put stringent requirements on it if we wanted to. We actually have
Because
on that land on how much development can occur on there, how much impervious cover could be on there, how many buildings could be on there. So how is it any different than that?
Because there's a notion of preemption.
Yeah.
And the state agency has jurisdiction ultimately.
So
For instance,
jurisdiction over
let me
our
give you an
town.
example. For instance, if there's a cleanup standard for arsenic that's 1 part per million by the DEP, it's not, and you have to clean it up. It's not as though the local town, in whatever town it is, can come up with some ordinance provision that says that you have a more stringent cleanup standard, and therefore you can't do your deal here because you have a drop of gasoline on your lawn, and therefore you're in violation of the ordinance. That's a sounds like a crazy analogy, but you asked the question. It's really not for this witness. It's a legal, as you said, it's a legal argument that can be made, and we stand by the proofs that we've made.
Well, and I think the township should stand by the fact that we have an ordinance and you guys should comply with it.
Understood your position.
That's the bottom line that I can see here. So I'm done.
Mr. Gupta, we fully understand the Environmental Commission's stance, and we think we have one of the best consultants on the face of the earth that testified tonight and previously, and we're confident that the judge will see it the way we've presented it.
Okay, well, good luck with that. Thanks.
Thanks. Good luck with the argument.
Mr. Bernstein, I just want to make note that Mr. Ford is here and I have promoted him. I don't know if Mr. Policastro knows that, but I just wanted to make a note.
I don't know, but I just like when you say that you've promoted him. It sounds like he's got.
That has nothing to do with the pay raise.
We have now made him a real engineer. Okay.
So thank you. I don't know who just spoke, but thank you for that information.
Yeah, that was Fred from IT. And there is one other hand up if we want to continue, Chairman.
Yeah, that's Ms. Whitey.
Yes.
And I do believe she may have had a question or two that were more engineering related. So let's promote that Mr. Ford is here.
Again, could you please state your name and address for the record, spelling your last name, please?
Marianne Sawade, SAWADE, 142 Johansson Avenue. My question is about the drainage and the stormwater system. I do not believe that we have received any valid hydraulic analysis of it. It has been proven that it was buried and not functional. And per the township ordinance on drainage, watercourses, and flood hazard areas, no stormwater runoff or natural drainage shall be so diverted as to overload existing drainage systems or create flooding or the need for additional drainage structures on other private properties, blah, blah, blah. You know the ordinance. This seems like it's a classic case of that happening. Mr. Ford, is he on?
Wait, before we move, Mr. Ford's not the witness right now, so could we finish with Mr. Affinord and then?
Okay, I'm sorry. It's a tough procedure to follow when you have questions.
We're still dealing with the witness.
Okay, so Mr. Affinord is not the stormwater expert. Okay, that's fine. My question is for Mr. Ford then.
Thank you.
Are there any other questions of Mr. Affinord?
I see Miss, no, her hand disappeared.
Yeah, it was up and then disappeared. Oh, it's back.
Right, it keeps going up and down.
Let me see. We'll give her 1 second.
Okay.
All right. I guess you can continue.
Right.
Yes, I don't know what she's doing. I don't know if she's having an issue or not, but
right,
I can't even quick enough promote her to talk.
Right. No, it's okay. All right.
All right, it's stuck on now. Let's see.
Okay. Okay,
Ms. Janusek, can you hear us? Can you state your name and address and spell your last name, please? I'm guessing she cannot hear us. So she still may be having an issue, Chairman.
Okay, so let's just, mute her for now. And I guess we are done with the witness for now.
Well, we would really like to be done with this witness forever. So if there's someone out there that has a question, I think it's now. I mean, this is the third time he's been.
Let's characterize. We are done with this witness. You're looking to be done with this witness's testimony. Let's not leave the record that somehow
let's keep it light.
Ill will of the witness.
Let's keep it light, Mr. Bernstein.
If you don't get any emails from me, call the police.
Mr. Chair, can I just ask one more question? I mean, since this is a legal issue.
This is Mr. Julian.
This is a legal issue in terms of home rule, township ordinances. What's either Mr. Maskey or Mr. Bernstein, what's your opinion on this? I mean, we have a town ordinance, 150-foot buffer on a stream corridor. So does the township have a stance? What do you think?
I'm going to hold my opinion at this time until everything is in and we get some more comments from the engineering and other professionals before I opine, if that's what the board is seeking. Because I suspect my opine is going to create an issue one way or the other.
What about Mr. Maskey?
I'll defer to council.
I have one point for clarification because I heard the word recommendation out there. So is the DEP's 50-foot buffer a recommendation, requirement, minimum, maximum, absolute?
It's a requirement.
A minimum or maximum, or it's an absolute?
Well, there's three levels, 50 feet, 150 feet, and 300 feet. Every stream is one of those three, and this one.
So DEP is opined. They have rendered via the email that was referred to.
Right.
They've checked that 50-foot box.
So, but does that 50-foot box is an absolute, minimum, maximum? I deal in regulations all the time from an FDA perspective. We have specifications, and we're very clear if they're absolute, minimum, maximums. And since I only have one metric right now, 50 foot, is it a minimum, maximum, or absolute?
It depends on the classification of the waterway. That's what it comes down to, right, Tom?
Yeah, that is the classification, a 50-foot riparian zone.
But if it was a C1 waterway, it would be 300. So
I see. Yeah, yes. Yes. So the streams are classified as various levels, and this stream has a non-trout water that doesn't drain to threatened and endangered species habitat, has a 50-foot riparian zone.
Okay. So we got a non-classification. Still don't know if it's a minimum, maximum, or absolute. So I'm sure
it's an absolute based on the classification of the stream. But what we're saying is we also have a township ordinance that complements that, and that's the legal issue. I mean, that's the $1 million question right now that somebody needs to opine or give some.
Yeah, and we also have testimony from Mr. Afenor that it's not necessary, and that, as you know, we've applied hypothetically, if it were to apply, we've noticed for a waiver of this requirement. And you heard this witness indicate that it's not needed, that this buffer, there's no need for it based on his expertise. So you can differ on the application, but I think we've covered all bases. A, it's not required, and B, if it is required, a waiver is justified because it's not necessary.
So, Mr. Chairman, from what Mr. Policastro just said, are you requesting a waiver or are you not?
Are you asking me?
From the stream corridor ordinance.
Are you asking me?
Yeah, I thought you just said.
No, I said that we've noticed for a waiver and that we don't believe it's necessary. It doesn't apply. But
right, you did notice for a waiver. From
in an abundance of caution, we did notice for one.
Okay.
And so that's always on the table, but you've heard testimony from this witness this evening justifying if we needed a waiver, because he's testified that this buffer requirement is unnecessary.
Thank you.
Okay, I'm gonna give the public one last bite at the apple for this witness. Okay, I do not
see any either, Chairman.
Okay. So Councilor, how would you like to proceed? Should we open up the floor for Mr. Ford?
Well, how much time do we have? That will depend on how much what is the stop?
We're just past 9:30. We won't take any new testimony after 10:30, so.
Yeah, so I think it would be a good use of time to put Mr. Ford on for the limited purpose of addressing the issues that were raised this evening, that were the questions that were really not for Mr. Affenord and that were for Mr. Ford relating to stormwater.
Okay.
That is okay.
This is Fred from IT. Mr. Ford, are you there? Could you unmute yourself?
I'm here.
Super. Oh, there you are. Thank you.
You had your chance, Mike.
Okay, so.
Mr. Ford, I will remind you, you are still under oath. You don't have to, I'm just reminding you, you have been previously sworn in. You are still under oath. You have been previously qualified by this board as an expert in engineer or a professional engineer. Mr. Policastro, your witness.
Well, good evening, Mr. Ford.
Hello.
How are you?
Okay.
So Mr. Bernstein, there were questions that were posed. And so again, my preference would be
That's fine. I'm as I said, before we
there are
before we threw Mr. Ford into the deep end.
Yeah, so to be clear, Mr. Affenord will no longer be, we're not going to bring him back. It sounds like we're not going to actually finish this evening, unfortunately. So there were certain questions, Mr. Ford, that were posed by board members and also a couple members of the public relating to stormwater. And Mr. Bernstein, I think maybe you can frame the issue.
Well, let me start with issue number one, at least my issue number one, Mr. Ford. I'm not sure it's everybody else's, but we'll start with this one. Obviously, as you are well aware, based on your own testimony and hearing testimony of others, as well as the public, an issue has been raised as to the current stormwater discharge off the property in its current condition. The issue is, what, if anything, does the applicant propose to do to more accurately measure the various 2, 5, 10, 100-year storms, et cetera, for runoff, to give all the parties, your client, my client, et cetera, the understanding as to what the current runoff is so that we can measure that against your client's application, that they will, under the stormwater regulations, not produce any more water off the site than is currently coming off the site, and in fact less. So, and as you know, I believe there really has not been a full-blown analysis of same.
Okay. Sorry, I didn't hear what's transpired this evening until this time. It was actually at another virtual hearing. But as I presented to the board back at the hearing in December, and I don't believe there was any dispute regarding our stormwater analysis, in that we, and this is actually even before the presentation to the planning board, this was a presentation to the Environmental Commission before coming to the planning board, that we are reducing the peak flows from the site for the 2, 10, and 100-year storm, not just, inches below what is required, the 50, 75, and 80% reductions, but significantly below that. And we presented numbers to that effect at that time. The drainage report bears that out. And at our December presentation to the planning board with regards to stormwater discharge, we acknowledged that there was concerns from the public about whether we connect to the existing township drainage system that runs along the rear of the property or the state open waters. And right now our plans call for a direct connection to that piping system. And we agree, I think, with the board engineer that that would be the best engineering solution, but we would defer to the board to connect either directly to that drainage system or the open waters. Both are at the rear of our property or the easterly property line. And we have presented calculations that not only comply with the township standard, but also the state standard. And we acknowledge that DEP will be reviewing this as part of our FHA permit. So, and then I think even globally, we presented at the last hearing that we acknowledge that the residents to the east of us have a drainage problem. We understand, we've heard their drainage problem, and we can even identify and see it easily on the federal floodplain mapping that shows the entire section of Dukes Parkway East flooded because of the Raritan River downstream of us during major flood events. And that our, I'll say 13 acres, half of it not being developed because of wetland constraints. Even if I were to not discharge a single drop of water from our site, whereas certainly there's drainage coming from our site today, if at the end of the day I didn't discharge a single drop of water from our site with stormwater control, we wouldn't be able to correct that regional issue that's resulted from development over years and perhaps the development of these properties back in the 60s or 70s when there wasn't a knowledge of floodplains like there is today, certainly of the Raritan River. So we've complied with the township standards. We've acknowledged at the December meeting that we would comply with each and every way, each and every issue and comment in your board engineer's comments to his satisfaction. And that's our position.
Mr. Euro?
Yes, Mr. Bernstein.
Any comments?
I concur with Mr. Ford. We have reviewed his drainage report and they do meet the township's stormwater requirements for retention of the peak rate of runoff, and it does coincide with the state requirements. He's also providing the necessary methods for meeting the standards for water quality also. So.
Do you, on behalf of the board as their engineer, have a comfort level in the calculations you have that we have a current accurate picture of runoff from this site as it currently exists?
So based on the mapping and plans that have been submitted, it appears that that water course drains from the Campus Parkway cul-de-sac area through the site and then discharges into the state open water ditch on the easterly property line. So based on the information that has been submitted as part of this application, there is flow based on the contours of the property and the mapping that shows that the runoff exists in the existing conditions, gets into that ditch on the eastern property line, and eventually gets collected into the 42-inch pipe via a head wall further downstream. Mr. Ford's plan continues to follow that same drainage pattern with the discharge in that northeast corner of the property.
Let me see if I can hone it in just a little further. And it's an anticipatory situation. Assuming for the sake of this discussion that this application is ultimately approved by this board, I anticipate that residents of the neighborhood will at some time in the future, sooner or later, come to the governing body and or this board and say unto them that things on my neighborhood are worse than they were before this application was built. Do we have the basis now to be able to do an analysis down the road as to whether or not that is quantifiably correct or not?
No, we cannot tell that based on the information submitted today. All I can say is that they are meeting the requirements of the ordinance. They are reducing their rate of runoff from the property. Now, how that impacts the overall drainage on the regional level, you would need to have an overall regional drainage analysis prepared, which will be, much larger than the 17 or 20 acres that are included in this design.
Is there anything that the board can ascertain or the municipality at this time that could address that issue in the future?
Could request for a downstream pipe analysis be performed.
Which would not necessarily impact this applicant per se, is that correct?
Correct.
Thank you. Mr. Chairman, does anyone have any other questions of Mr. Ford before I know that there are members of the public waiting with open arms to ask him questions?
Yeah, I just wanted to bring up my point that I made when Mr. Ford was not here, which was that when we walked the site, there was nothing going into that 42-inch pipe currently because the water was just kind of sitting there in the stream, sitting there on the site. We barely were able to find the pipe and the grate. So the reality of what is there based on all the calculations that you made was different. And it's hard to determine what's gonna go into the pipe as to what's already going into the pipe. So therefore, we felt that more analysis should be done because you really don't know how much is going in there right now.
Perhaps I can address that by saying that since the December hearing, we provided not sources from our office, but sources from the Township Engineering Office that identify the 42-inch pipe that was installed in the 70s included open grates that would allow for open drainage from this site into it. The lack of maintenance on behalf of whoever might be responsible, the applicant, the township who installed it, that could be, left to higher authorities. But ultimately, even beyond that, those plans that we provided also identify that the 42-inch pipe with the drainage feature, the state open water that runs along the easterly side of the subject property all enters the same system, literally, within a short distance downstream of the site, identifies that they're all part and parcel of the same system. And as I said just moments ago, back in December, if it were the board's discretion that we not connect directly into the existing storm drainage system, as we suggest, and the board engineer suggests, but directly into the ditch on the neighbor, along the neighbor's rear property line, we would do either one. We're comfortable with our on-site drainage system that reduces the peak flows in accordance with the state standards and the township standards. And then beyond that, since the last hearing, we've not only identified the township's plans for the drainage improvements that were installed, not for our property, but I think to improve drainage for the neighbors because of historic issues with the development of the residential properties east of this tract. But we've also provided documentation from other sources, including NJDEOT for Route 206 that identify the drainage in Route 206 doesn't flow toward our property, doesn't flow toward lot 104 to the west of us, but the flows under Route 206 toward the west of us. And I believe that the board engineer has now seen those documents and agrees with what DOT intended with that drainage, that doesn't flow toward our site. We're comfortable with the storm drainage. And again, ultimately, overall, unfortunately, I would say that regardless of whether this development happens or doesn't happen, it's not going to rectify the ongoing drainage issues. That includes feet of flooding of some properties along Duke Parkway East because of the Raritan River.
Yeah, but you're designing the system to go into the pipe. I think it's a better idea to have it go into the pipe. But what I'm saying is we don't know because there's nothing going into the pipe right now that we saw. So based on that, it's kind of a hypothetical. And that's my point.
Well, I think what I would offer as correction to what your statement is, from an engineering standpoint, it does all go into that pipe. Whether it goes into a grate immediately behind the site for the lack of maintenance or non-lack of maintenance, or it goes directly into that pipe, literally within 100 or so feet north of the site by a direct connection of a head wall into that pipe system. It all happens now. And again, we've not disputed whether you want us to connect directly into the state open water or the pipe system. We agree with the board engineer that a direct connection would be better because the system is all connected anyway. But if it's the board's pleasure, we would do either one.
I mean, I would hope, but I don't want to go on hope. That's why maybe some downstream analysis would be worthwhile. And I guess that's what we're saying.
I would offer too that the board's consideration is that certainly the lack of drainage or the disconnect that you may have witnessed within the last couple months of some drainage from this site to the east to that existing swale is not because of action from this applicant or natural occurrences of the property that we're talking about, but because of action by others, which may include the township or the HDMUA, with the connection of storm drainage and or sanitary sewer pipes that run along the easterly tract boundary of the site, which really, I'll say, effectively bermed drainage from this site into that swale.
Yeah, I don't know if I would agree with you on that, but that's a matter of interpretation.
Yeah, I just don't see it as a natural occurrence. I would say that's that berm right over top of storm and or sanitary sewers that have installed. And please, also, the board should know that there's not just one sanitary sewer line that runs along the back of this property, but two. And
well, I think it runs the corridor, Mike. I mean, it runs, almost into Manville, I think.
Oh yeah, absolutely. This is a 27-inch line and a 24-inch line,
right? And
they service a good portion of Hillsborough Township. And again, here's another. I'll agree with you, sir, that we've gone to great lengths to not secure mapping from our office, but again, we secured mapping from the Township Engineering Department for the 1970s improvements for the 42-inch line, but and the mapping for Route 206 for the drainage along 206. But we've also secured and made part of the record. This is on the township website for this site, but it's certainly part of the township records. The HTMUA's mapping for their improvements for those sanitary sewer lines, and they identify the existing 42-inch line and identify the manholes over that 42-inch line with open grates. And if a storm sewer line is not intended to receive overland flow, it would not have an open grate.
So would you guys maintain those grates?
That's another, I'll say, not an engineering question, but I'll say a legal question, because the storm sewer easement that runs along the easterly property of this site was not really for the benefit of this site or this applicant, to my understanding. It was to the benefit of the residents to the east of this property and that whole community, to try to provide a storm sewer pipe that would bypass their community, run through this site and directly to the north side of Dukes Parkway East. So the responsibility of that drainage easement and that drainage system maintenance, I'll say I would defer to legal questions as to whose responsibility it is to maintain it. Because certainly the major, I'll say, intended benefit of that was to try to resolve these ongoing drainage easement or drainage issues that were known in the 70s for the community to the east of us.
Before Mr. Ford, we open it up either to additional board or public comment. I don't believe you were here for the testimony. There was a question raised by Mr. Julian, among others, about the mound. Do you have any information to provide above and beyond what you previously testified to as to the existence of said mound, what it is, where it's from, and what causes creation, if you know?
Is this a mound of dirt?
I don't think that question is for Mr. Ford.
Whose is it then, Mr. Policastro?
I think Mr. Weiss, actually.
Okay, are we going to,
Sure.
Mr. Weiss, always a pleasure.
Hello, Mr. Renzi.
We swear Mr. Weiss in?
Please do.
Oh, all right. Mr. Weiss, I'll just swear you in the event you haven't been. Do you swear any testimony you give tonight is going to be the truth, the whole truth, and nothing but the truth?
I do.
And for the record, could you state and spell your name, please?
Robert Weiss, W-E-I-S-S.
Thank you.
Mr. Policastro?
Mr. Weiss, you're the principal of the applicant, is that correct?
Yes, I am.
You've heard the question relating to the mound and soil?
Yeah, yes, I have.
I understand you have a fairly brief but direct answer to that question.
Yes, I do. Approximately about 18 or 20 years ago when we started this project, what we did is we cleared the property to the wetland buffer line. So all the trees you see out there are actually a second growth. We actually had all that cleared. And at the same time, we also stripped the topsoil because we were going to start a office flex building, which was what we had the approval there before. So I don't want to testify that I know exactly every grain of sand that's out there, but in general, and engineers can opine on this, is that when you strip topsoil, you try to put it into piles in an area where they're not going to get in your way. Generally, you don't want to make a huge pile, one big huge pile in the middle, because it becomes very hard to work with. So in general, and in most site plans, if you see, they will have a location, maybe not on this one because it was just for a building, but in larger site plans, when they strip topsoil, they will put a location of the topsoil pile. So I don't want to testify that I know every drop of sand or dirt that's there, but if you can imagine, If you strip 5 or 8 inches or 10 inches of topsoil, sometimes over a with probably about a 6 acre or more, probably close to 8 acres of space, that's a lot of topsoil. And you generally put those in piles and you stabilize them in the hopes that you use whatever you're going to use at the end of the day, and then you truck off the stuff that that you're not going to use. So this was done a long time ago. Same time when we actually did the action one after the other. We came in there, we cleared the property, and then we stripped the topsoil. So they'll probably be in uneven piles. They probably might be in different locations to be out of the way of putting in storm sewer and these kinds of things that surely should have been out of the way of where the foundation was supposed to be. And that's the short answer as to what you're probably seeing out there.
Mr. Julian, do you have any questions since you initially raised the issue?
Well, I guess Mr. Policastro testified that they're going to do some type of phase 1 or whatever.
No, I did not. No, that's actually not what I said. The question was, would we do one? And I said, we did not believe a phase 1 was necessary, but we would, of course, comply with whatever regulations are applicable. And if
so let me ask a question, Mr. Weiss. Has the mound, any or all of the mounds, been tested since? Well, let's go back one step. From a time frame point of view, do you recall when this was done?
I can get you the exact date. I'm going to say Mike, do you know the date of your plans, your old plans? Any chance?
Mike being Mike Ford.
Mike Ford.
That's Mr.
I want to close the gap. It's been a lot of years.
I understand. So. I just want to make sure which Mike we're talking. Yeah.
Mike Ford. I'm sorry.
Yeah, Mike Ford. About 20 years ago, there's actually historical aerials on Google that show the construction started during the period that Mr. Weiss is testifying. That is the entire site clearing and the earthwork that was done.
So in roughly the last 20 years, Mr. Weiss, has any and or all of the mounds been tested?
Well, you don't test soil that just came off your property as topsoil. There were trees that are growing there before. It was never a farm. It was never anything else. So there would be no reason to test it, and it would be straight topsoil. So the answer to that question is no.
Okay. Do we know that the only thing in these mounds is topsoil and possibly trees?
Well, the trees wouldn't be in there. The trees were taken out, but it would be topsoil, and topsoil, as you know, is, or you may not know, is organic matter. You can tell by looking at it when it's topsoil, although some of the topsoil in that area is pretty poor, so it's mixed in with clay. No, we didn't test anything, and we haven't really been on that property. We haven't done any work on that property. As you can see, or the gentlemen that have walked the site, you can see that all the trees have grown back. And so obviously we haven't done anything or moved any dirt around or brought any dirt in. It's been basically an overgrown site that's been sitting there for the last, I would say, about 20 years.
Mr. Weiss, would you know if there's any outside fill that was brought there?
I wouldn't be aware of that.
Do you plan on using that topsoil as a part of your development from this mount?
Yes. But generally, what you do is you don't. There's an old joke: when you need topsoil, you pay for it. When you need to get rid of topsoil, you pay for it. So, what you try to do is you try to balance the site, and then there's obviously some landscape features, there's berms and things like that. So, there's also some recreation area and some open space area, doggy park. So you generally go back and spread about 6 inches of topsoil into the area, and then whatever you're left with. Usually take off the site, or you see if your next door neighbor needs it or something.
And I guess the only other issue is, would you know if it would affect the drainage? But I'm not sure if that is part of the development itself. Obviously, it affects the drainage now, but potentially, I guess you're going to move that. So,
yeah, no, it's a stock pond. I mean, I guess that's the description I should have used to begin with. You strip the topsoil at the beginning of the job, and unfortunately or fortunately, you don't touch it again until the end of the job. So you generally try to put it in a spot that it's okay, you try to shape it up. Generally, the township asks you to stabilize it, so you throw seed on it and it starts growing grass and kind of sits there during construction, and that's usually the last thing that happens is as the landscaping is done, that you use what you need and you export what you don't.
Any other board members have any other questions of either Mr. Ford, who has gone hiding, or Mr. Weiss?
I do have a question for Mr. Ford, Chairman Sirachi. There was some discussion regarding reduction of peak flows, and is it confirmed, or can you confirm, like the 13-acre site, it drains today, it's undeveloped. When the site's developed, it's going to have roads and capture devices, drains. Is it the case that after the site's developed, that when you say a reduction of peak hour, is it true that after the site's developed, the runoff will be less in terms of a controlled peak hour, or is the runoff more after it's developed?
Yeah. There's township standards, state standards. We've followed them, and for example, the 2-year storm requires a peak reduction of 50% the peak flow of the existing 2-year storm, and that analysis includes analysis of, not including those areas that are not draining to the drainage system. That is the areas that are not developed. So it includes the areas that are developed that wouldn't stay in their natural state and would be encumbered by impervious coverage, buildings, and so forth. They're all captured in an underground stormwater management system. And I'll say, at the very beginning, back when we met with the Environmental Commission, one of my first statements was, we haven't endeavored to just meet the reduction requirements by 49% or 49.9%. We've reduced them below that. So we've met the standards and exceeded them.
So is it the case it's less?
Yes.
Less after it's developed, peak hour?
That's correct.
Okay. And Mr. Euro, that is correct?
Yes, it is, Mr. Remy. That is correct.
Thank you.
Any other member of the board?
Mr. Ford, you mentioned the current plans that the HTM MUA has. Can you elaborate on that, or has that been uploaded to the site?
Yeah, I believe it's on Civic Clerk because we provided it to the township. After the December hearing, we understood there was concerns about what existed or didn't exist along our easterly boundary. We didn't endeavor to just produce surveying data from our office, but to produce surveying data that is as-built data from other sources. And we endeavored to not only contact the Township Engineering Department, but also the Hillsborough Municipal Utilities Authority for as-built plans for their existing sanitary sewer lines, 2 sanitary sewer lines along our easterly boundary, and provided, basically taken from one township department to another township department, those as-built plans, that is from the HDMUA to the planning department, so they could be readily available on Civic Clerk. And this is, to also provide Mr. Euro with documented mapping of what exists out there today.
Yeah, I see. And what I'm following up with is, I thought I heard you mention their future plans. And
no,
that's why I'm asking. I see.
Yeah, no, I don't believe I said future plans, and I
I'm not aware of any Hillsborough Municipal Utilities Authority's future plans for improvements to their existing regional sewage authority collection system. And as one of the other board members stated, these are not small sewer lines that for collection. These are our major sewer collection lines that run along the easterly boundary of this site.
Yeah, I understand that. Maybe I heard what I wanted to hear.
And that's all wastewater.
Yeah.
And then, for residents that are, perhaps looking at this, the manholes for the wastewater collection system protrude substantially up out of the ground. Their manholes are elevated 3-4 feet out of the ground. And that's, from an engineering standpoint, on purpose, so they don't collect overland runoff. So I believe there was some pictures provided by a resident that showed, here's these manholes. They obviously can't be collecting storm runoff because they're elevated feet out of the ground. But those same manhole pictures said sanitary sewer. And the reason they're elevated out of the ground is because, sanitary sewer is just for that purpose, to collect sanitary sewer, not overland runoff.
Okay, thank you.
Mr. Ford, this is Mayor Lapani. And I know you weren't here for a lot of testimony, but there was a question asked the environmentalist about the calculations and the fact that the permit was removed because they were going to redo the calculations of the runoff of the existing land. And the question from the public was, what type of calculations or what changed or what is the math that is being done that to calculate the existing runoff on the property? Do you know that answer?
Yeah, that is, I think you're referring to an NJDEP permit. There's a current pending NJDEP permit for wetland impacts. That hasn't changed, and they are minimal. There's a buffer averaging for some averaging of the wetland buffer for the project, and then also some minor intrusions into the wetland areas for the connections to the stormwater at the easterly portion of the property. With regards to the flood hazard area verification, there was a question from NJDEP about the analysis of the flood hazard area for the existing state open water along that water course that coincides along our easterly boundary with the neighbors to the east. And albeit a man-made drainage feature, it may have a drainage area over 50 acres and require a detailed engineering analysis. And that's what's happening right now, that detailed engineering analysis. And that detailed engineering analysis may result in identifying what I think a lot of the neighbors acknowledge, which is a flood area that impacts their properties, and the western portion or the eastern portion of this site that's wetlands.
Well, that is submitted to the DEP for permitting process and determine the wetlands and whatever else that they give for approvals.
Yes.
And when do you anticipate that being finished?
Prior to March 1st. By the end of this month. It's although it might not necessarily impact this project because we're over 200 feet from that drainage feature that, I think everybody acknowledges collects water runoff from the residents to the east as well as residents to the south and properties to the south.
that analysis is a detailed analysis with stream cross sections and a hydraulic and hydrologic study that's being done as we speak and would be submitted to DEP by the end of this month.
Thank you.
Mr. Ford, Mr. Euro, that analysis is on the state open water ditch on the easterly property line you just stated.
That's correct.
Now, will that include any calculations or anything to do with the 42-inch storm sewer pipe that runs parallel to that ditch?
To the extent that the 42-inch line relieves some of the runoff within that state open water, yes. But actually, I'll say back in the fall, one of DEP's immediate responses was that they would rather we not take any credit, for what that township improvement for drainage provides for that state open water. So the analysis is, ongoing and figure out what that result would be.
So it's a worst case analysis for that ditch.
That's correct.
Thank you.
I'm just looking at the clock. It's about 20 after 10. So any more questions for Mr. Ford? Because I do see a hand raised in the audience. I'd like to try to get that in.
I just have one more question. It should be a quick one. Mr. Ford, it's stormwater related again. I know you're using a subsurface chamber system, which is common. I see them going in elsewhere in Hillsborough. I understand it's like 7 feet below the parking lot, the finished grade of the parking lot. Did you guys do test pits yet to determine that you have the necessary distance from groundwater for the recharge? Did you guys test pit to just ensure you can use that type of system on this site, especially with, close by wetlands?
Yes, the part of the stormwater analysis, including on-site soil testing.
Okay. And Mr. Euro, I'm just going to look to you for a second to confirm that. I trust you, Mr. Ford, but
no, that's fine.
To a point, he's the board engineer, so.
Yes, we did review that and it meets the requirements, but based on all of the discussion, we will look at it a second time just to confirm.
Okay, thank you.
No objection.
Okay. All right. If there's no other questions from the board, oh boy, I see a second hand. So if we can promote Miss Marianne.
I got it, Carl. Thank you.
All right.
All right. Again, please state your name and address for the record and spelling your last name, please.
Marianne Sawade, SAWADE, at 142 Johansson Avenue.
Thank you.
Thank you. I'm questioning the new stormwater ordinance and how that affects this application. Is this relevant to ask? I believe it is.
Ask the question, Ms. Swade. We'll see where we go.
That was my question. Thank you. How does the new stormwater ordinance that was proposed, I don't know if it was adopted. I thought it was just proposed the other night. How does it affect this project? I have a hard time figuring out what it's saying as opposed, in relation to this project.
And by the way, it will be an ordinance that I believe, correct me if I'm wrong, Mayor and Deputy Mayor, will be adopted either later this month or early next.
Okay.
Because everybody's under the same time constraints.
Yeah.
Okay. I was reading it and I was just having trouble understanding how this affects future
Mr. Ford.
development in this township.
Mr. Ford, can you, on behalf of your client, indicate whether or not the new model stormwater ordinance will apply to this application, if you know?
Yes. Okay. I haven't reviewed the pending township stormwater ordinance, but it's my understanding that if it's consistent with what DEP is proposing, it's primarily related to water quality, not water quantity. So with regards to flooding or adverse drainage impacts on neighbors. Quantity is always the concern. And it's my understanding that both the state standards that were adopted about a year ago would require water quality measures to be enhanced, but not water quantity. And then with regards to a pending ordinance, I would defer to legal minds greater than mine, but it's my understanding as a professional engineer, having done this for 30 years, that when you have a application pending, it's been deemed complete, and the township perhaps adopts new ordinances during the review of that application, that those new ordinances cannot be applied to the new project. All that being said, I would hope that everybody is relieved by, in some respect, that the new stormwater regs, to my understanding, are all about stormwater quality enhancements, not quantity.
Quantity is what's important to my neighborhood.
Understood.
The quantity is what affects us, and that's the only thing that affects us. It's not about the affordable housing, and I know that's the angle you guys are going. I know you want to make money on this property. I see the whole picture, but we are going to be severely
So,
affected.
Mr. Chairman, I don't know if there's another question for this witness.
My question, Mr. Policastro, calm down. I'm about to
I'm
ask
very,
a
very
question.
calm, respectfully. I'm respectful.
I will indicate, Ms. Swady, I will indicate just for the record that Mr. Policastro is abnormally calm for the moment, but okay.
That's funny. Okay, so I have a hard time not making a statement in order to make a question, because sometimes you have to state a fact before you make a question. So don't you agree in your legal expertise?
Let's move it. No, I do not agree.
Oh, okay. No, you never make a fact before you make a question. Is that the truth, Mr. Policastro?
Ms. Swady, do you
No
have a
answer.
question? Do you
Okay.
have a question for Mr. Ford or Mr. Weiss?
Okay. My question was about the stormwater ordinance, but I don't think it was actually answered.
The answer is, I can indicate, because I've been reviewing too many of them over the last 2 weeks. The ordinance is to put into place the stormwater regulations that the state adopted approximately a year ago, of which municipalities were supposed to have introduced and adopted these ordinances, and many of them are, in the next 30 days. They ostensibly deal with, I believe, and Mr. Euro, correct me if I'm wrong, they ostensibly deal, as Mr. Ford indicated, with quality and not so much quantity. But to the extent that they may or may not apply, and the issue of application, I believe, is set forth, and correct me if I'm also wrong, Mr. Policastro, I believe the language is clearly set forth in the model ordinance as to exactly who it does and who it doesn't apply to in terms of pending or existing applications. And obviously, the township will be governed accordingly.
Of course, and I think there's also the time of application rule, Mr. Bernstein.
That I understand. I'm just saying, for the purposes of the, I believe, my recollection is that the ordinance itself discusses who it is not applicable to for a change of pace for the state.
Right, so I think that question has been answered, and I appreciate the response, Mr. Bernstein.
Okay. Any other questions, Ms. Swady, of either Mr. Ford or Mr. Weiss?
Not at this time. Just want to say I have a petition with 2,086 supporters against this project of Hillsborough supporters. Before you and
Mr. Policastro, there will come a point in time, which I suspect is the next hearing, that you will get to make any and all statements you want the board to consider and to present. My suggestion is, if you have a petition you want the board to look at, that you provide it at least 10 days before the next meeting. We will forward it on to Mr. Policastro. As for those of you who are not aware, we have forwarded everything on to Mr. Policastro. We have also forwarded everything on to Ms. McManus. that you have all submitted so that you all know it has gone to not only the board and the board professionals, but the applicant's counsel and the court special master.
And we're appreciative of that, Mr. Bernstein, and I can acknowledge the receipt of those
So,
materials.
Ms. Swady, the statements get the next time.
Thank you, Mr. Bernstein, as always.
Thank you, Ms. Appreciate it.
We're coming down, and then I've got 2 hands up, and I think that's going to be the last 2 audience members for the evening because we're getting close to the 10:30 time. So can we promote Mr. Abrupta again?
Again, Mr. Abrupta, please state your name and address for the record, spelling your last name. Thank you.
Yeah, Christopher Abrupta, OBROPTA, 605 Cornwall Court, Hillsborough, New Jersey.
Thank you.
Well, these meetings go long. I'm glad I'm not on this planning board, but I appreciate the work you guys do. Mr. Ford, I just kind of a quick question. You mentioned that there is a kind of a berm on the eastern side of the property over where those sanitary pipelines are, and that seems to be obstructing flow from getting to that 42-inch pipe or that drainage ditch back there. So I guess my question in your stormwater calculations, I did review, and you are appropriately reducing the peaks for the 2, the 10, 100-year storms. But the assumption is that your pre-existing conditions is that the water is all going to that drainage system. And I'm not sure that that's an accurate assumption because of the way the land mass is and the way that berm is built up and the way the existing pipe, I guess the inlets on the pipe, the open top manholes were covered up until recently. So I guess I'm wondering, aren't you concerned that, since water may not have been getting there the way you anticipated to be getting there in your pre-existing calculations, and now you're going to be adding more water to that area, that it may cause a backwater effect and an additional flooding onto Johansson Ave? Is that a concern of yours at all, or?
All our drainage goes to the east. The fact that there was perhaps a lack of maintenance on whoever's part of the existing drainage system, just like I can't take credit for changes in land cover over the last 5 years in my drainage analysis, the deficiency of maintenance, I don't think would change my view in that our drainage drains to the east.
So
there's not.
I don't want to interrupt, but so basically you're saying that the pre-existing conditions are, what they should be, whether it's functioning properly or not, and now your post conditions are going to reduce that flow that would be going there. So, do you see any benefit that the township should do to really do a further investigation of the system to truly understand the capacity of that system behind those homes and how this additional flow might affect that? I mean, do you see that might be something to be done in the future, and maybe not on the back of this development, but on the back of the township?
If you know, Mike, if you know, I mean, if it's not related to this development, it's not really relevant. But if you know, that's not something you really have to.
Right. I appreciate that, and that's, I'll say the Boy Scout in me, and I said at the December hearing, we're meeting the standards, but we're not interested in it to the extent we, any project we can improve an existing problem for any resident. We would like to do that, for any project, and would discuss it with a client. In this case, the project, the problem is regional. It's not isolated or small. And to answer your question, in looking at this project, they're perhaps just like the township in the 70s recognized a drainage problem for an existing residential community and took it upon themselves to construct a 42-inch pipe that basically diverted drainage from around that property or around that community onto other people's property through this applicant's property and lands to the south of us, acquiring easements to do so, to the Environmental Commission members' credit, I agree that that perhaps could be something that the township could consider. For example, south of that community, there's township-owned lands that perhaps could be a location for a regional drainage system that the township could endeavor to undertake apart from this application to help solve these residences' problem.
So, I mean, when we develop land, we really look at an individual site. We don't look at any real regional issues. But this development certainly has exposed some regional problems in this area. And I would strongly encourage the township to look into this further, because these residents are going to continue to get flooded out. And I tend to agree with you, Mr. Ford, whether this development goes in or not, there's still going to be flooding in this area. And I'm not sure exactly how this development is going to, if it's going to increase that or decrease that, but I do believe there needs to be additional studies done here, and I'm hoping the township will certainly look into this. Thank you.
And Mr. Brupta, I'd like to just add, unfortunately, it may not just be in the township's hands, because like, as I stated earlier, and we provided, and I think this was in one of the documents that's on Civic Clerk for all the public to see, the FEMA map that is the flood insurance, maps for this area identify that Dukes Parkway East is flooded. Just as some of the residents, I think, during some of the public testimony, identified some houses within that community with, over a foot of water in them, and the community being cut off from access, road access. Unfortunately, that's a result of flooding from the Raritan River, which is regional beyond even the township's hands, and a consequence of development procedures that occurred 40, 50, 60 years ago.
I'm not sure how much of that flooding from the Raritan really backs up to this section of Johansson, as opposed to what's coming in from Brooks Boulevard and coming from the other side, from south of the property. So, and I think that's what needs to really be explored. Like you said, is an opportunity. I mean, there is a detention basin back there. There's an opportunity to do something more regional back there to prevent some of that water that's coming from the other developments, into behind these houses, and really try to protect these homeowners' interests. So, okay, thanks. I've had enough. This has been great. We should do this again in a few weeks.
Thank you, Chris. All right, Carl, we'll take people keep raising their hands. You want to just take the J. Tatunjan?
Yeah, I think that's going to be the last one. I had said that we were doing two more because we're past 30 at this point.
Great. Okay, could you please state your name and address for the record, please, spelling your last name?
First name John, last name Tatunjan, Tutunjian, and the address is 150 Johansson.
Thank you.
Mr. Ford, when you originally were hired to do an assessment on this property, did anyone from your firm walk the property and evaluate the property prior to starting your assessment and your work that you accomplished as far as drainage and how the ecosystem worked prior to your work for the client?
Yeah, I actually, Van Cleef Engineering Associates, which has been in existence for over 45 years here in Hillsborough. Our headquarters office is located here in Hillsborough, has been involved in the development plan exploration for this property for many years, and was part of the development of the plans for the previously approved industrial building that was proposed for this property over 20 years ago, as Mr. Weiss indicated was approved and actually started constructing and stopped. So the answer.
So you used your assessment and your evaluation from 20 years ago on the property. Is that correct? Or Did someone?
No,
come-
I'm answering your specific question. You weren't asking me if I was there yesterday or the day before over time. I'm trying to give you a perspective of not only for this project, but more than 20 years ago, our office has been involved with the development plans for this property, including site inspections. And that would be from various employees.
Yeah, so my question is, when's the last time yourself or anyone that reports to you actually walked the site and did an assessment on the current conditions? When was the last time that happened?
Within the last 30 days.
Okay, within 30 days. So a year ago, when you started doing the planning, which is very crucial for everyone involved, right? The drainage, no one walked it, no one did an assessment. And we know that as a fact. No one can argue that, because two open grates that you stated on your plans for this to work were not open grates. And we have testimony from several people that walked the site that said they were buried. So my point here is, you know, if this is really high importance to yourself, to our community, how can that be overlooked? That should be the first, in my world, maybe I'm looking at it the wrong way. That should be the very first thing you do. Before you even start, you should take an assessment. You should walk it and see what the current conditions are, not from 5 years ago, 10 years ago, as-built from 1970s. I mean, I don't understand how much time that would take. Wouldn't that be very crucial for you to do prior to starting your evaluation and your planning? Because that may determine or change the way you designed the drainage, correct?
Yeah. Okay. As part of our analysis and design, we're not looking at one day or even a year. We're looking at over time and the development assessment and what was intended. And certainly we've established an historical record starting back in 1970 when the township installed the storm drainage 42-inch pipe that you're referring to along the rear of this property with open grates rather than manholes that would collude flow. And then put that all aside, sir. Both the storm drainage pipe, the 42-inch pipe you're just referring to, and the open ditch that runs along the properties at the rear of Johansson all connect literally just feet downstream of this site. So they're all part of the same system. So from an engineering standpoint, we're not looking at a little area. We're looking at a more substantial overall drainage area, and we're considering it all.
Yeah, so, yeah, but my concern there is, in a perfect world, you're right. Everything goes into a 42-inch main. Wherever it ends up, it ends up. But it's not a perfect world. And if we don't design this correctly, it's not going to get to the point where you're saying, and it's going to back up and we are going to flood. And when the back end of Johansson floods, it's going to look like the front end of Johansson. And that's a fact. And we know that.
I'm sorry, sir. From an engineering standpoint, I just don't agree with you.
Well, no, let me just give you a little historic, and you know this, back in when the complex was first built and they didn't have that 42-inch main, and the water wasn't able to get there, the back end of this complex flooded. And we know from people that have resided here from the beginning that the end of this block was a few feet underwater. So that's why it's essential for us as homeowners to make sure you're doing your due diligence to make sure the water gets where it has to go to that 42-inch main. And with that said, it's crucial right now when you're doing your evaluation and assessment to understand that the water is not going into that 42-inch main. It's sitting, it's going through a swell across certain, whatever natural way it's getting away from our property, it is. So that's why we're really stressing that you need to do the proper evaluation and do a study to make sure it can take on that water. Because when it cannot take on that water, that 42-inch main cannot take on that water, or the whole back end of our complex will flood. And that is the fact, right? If that 42-inch main, let me ask you a question, Mr. Ford. You know the history very well, better than me. If that 42-inch main cannot take on water, no more water, where's that water going to go in your expertise?
Yeah, all of our drainage drains to the east toward the rear of our property. We've complied with the township and state regulations for the reductions in our peak runoff for the development. So without this project, in the current state, the peak runoff from the site would be greater than when we developed the project, and we have to meet those reductions for the 2, 10, and 100-year storm.
I think that Mr. Ford, I think that answers that question.
Yeah, thank you.
It is the same question, and thank you for answering it again. I think it was very well laid out. But that is the answer that you gave previously, and I think that is the answer that you're going to have if that's asked in a different way.
All right, so my last question is, and maybe this is for, maybe there's a reason behind it. Why not take the water and run it off towards 206, the drainage that runs down 206? Why go towards a problematic 42-inch main or 42-inch storage pipe? Why not spend the money? You're not too far away. Why didn't you send the water out to 206 where there is no flooding problems right now? Why are we tapping it to the rear of the property? Is it a cost savings, or what is the reason why not to go out to 206?
Yeah, the drainage flows in that direction today. That's what we meet the criteria for. And to the extent you make a statement about the flooding of Route 206, it's my understanding from the FEMA maps that there actually is a flooding problem of Route 206 near the crossing of the Raritan River just north of this site. So we can't.
So let me get this straight. Wait. I just got to interrupt you here. So you're telling me you don't want to go out to 206 because it could potentially make more water on 206 down by the bridge, which it does flood. But it's a better idea to send it to residents.
Sir, I'm not saying that.
Okay.
I'm responding to your comment where there's no flooding on Route 206, and I'm saying it's my understanding that that's not my understanding. And I'm also saying from a factual standpoint, from an engineering standpoint, our drainage analysis is for the drainage areas that currently exist. And if our current drainage area exists today, flowing to the east, which I don't think anybody's disputing, we're meeting the criteria for the reductions. I've said it multiple times, different ways.
Thank you.
But you didn't. Let's answer my question. Why? Okay, it naturally flows towards the east and the rear of the property, which we all know. I mean, you've stated that it wasn't your concern, but it's the township concern, and obviously our concern that it's problematic and it's not working the way it was designed. We're all agreeing that there's a major problem. So my question to the applicant, to relieve some of the stress and problems that we're having, why not send the water that you're pumping anyway towards 206? Why not send that water out away from us, or flow the water towards 206 drain, or half of it, or some of it?
Sorry, Mr. Ford has answered that question. We've complied with what regulations apply, all of them, and the board engineer agrees with that. So that is our answer, and hopefully that's what's responsive to your question.
So the board engineer, Mr. Euro, you're saying it's better to flow it the way it's going, or back or towards 206? What would be better? Let me ask this question then, Mr. Euro. In an ideal world, I don't know what the money situation. What would be better for the flooding problems that exist today, where the water should run?
To the east. Bottom line is your ordinance, the township ordinance pretty much states you got to follow the existing drainage patterns. The water does not flow to the west today, so you cannot change the drainage flow and make the proposed go in a westerly direction. It flows currently to the east. You have to follow those same drainage patterns in the proposed conditions. Otherwise, you run the potential of creating impacts in the other drainage areas to the west or further to the north of the property. The intention of the drainage scheme is to continue to follow the existing drainage patterns as to where it goes in the existing conditions. So in short form, it doesn't flow to the west today. In existing, it cannot flow to the west in the proposed conditions.
Has there been any other complexes in Hillsborough that you know of that actually have changed or through variance or ordinance changed the flow of water or no?
Not to my knowledge, and as I mentioned earlier in the evening, I've only been involved with this board for the past 2 years.
Okay. That's all I got. Thank you.
Thank you.
Thank you. Chairman, up to you. On you.
It's we're just about past quarter 11. I know we do hard stops at 11. I'm going to leave it up to the board. There are 2 hands up. We'll try to push through these 2.
Yes.
Okay.
Okay, Mr. Foley, you could please state your name and address for the record, spelling your last name, please.
Excuse me, Mike Foley, F as in Frank, OLLI, 38 Garrett's Lane, Hillsborough, New Jersey. And again, full disclosure, I am a member of the Environmental Commission.
Thanks,
I
Mike.
got a question for Mr. Ford. Keep it short, Mike, hopefully. Can you confirm for me that the plans that the existing plans that you use for your analysis for your stormwater calculations, can you just please confirm that they were, I know you use the terminology, but terminology matters. So I just want to make sure we're speaking the same language. Can you just please confirm to me that those stormwater reports were based on previous as-built plans as opposed to previous construction approval plans? Because they are different.
Yeah, we've, since the application's been submitted, and, during the development of even this current project plans, we've updated our as-builts, including, for example, when we met with the Environmental Commission, I think back in August, there were site-specific tree location survey information provided. So there's been site-specific survey data and analysis done since the prior approval some 20 years ago.
Oh, there has. Okay, that's
Yeah.
great.
Yeah.
And that has included survey of existing grate and inlet elevations?
Yes, and actually, Mr. Euro, through the course of this deliberation of this project application, has asked for updated, even confirmation of what's out there today. And I know there's been site visits by not only Mr. Euro, but the Environmental Commission, and they're.
Well, I'm not talking site visits. I'm talking specifically, survey work.
Right.
Okay.
Yes. Yeah.
Okay.
Yeah.
Okay. So there has been updated survey work recently for in the elevations and okay, great.
Yes.
Thanks, Mike. Those are the only questions I had for you. If I could ask Mr. Weiss a quick question. Is that allowed?
Yes, go ahead, Mike.
All right, great, thanks. Hi, Mr. Weiss. Just real
Hi,
quick.
sir. How are you?
Regarding the stockpile, I know you said it was topsoil from on-site sources. Just for clarification, it's been 20 years. Topsoil can grow over time. Does that mean that you will have to do some additional stripping of topsoil? Maybe not the same extent, obviously, that you did 20 years ago, but that topsoil pile would likely get bigger, at least a little bit? mean, you will have additional topsoil that's developed over the past 20 years that you'll have to make that a little bit bigger? Or you don't plan
I
that?
can't really answer that question because you don't know what you have. First, the site has to be cleared, and then once the site is cleared, then you see what you have left.
Okay.
I can't answer that question because I just don't, it's been over time, generally.
That's why I'm asking. That's
Yeah, it hasn't been farmed or tilled or anything like that, so I don't think this topsoil is going to grow. But
Okay.
I'm not really qualified to answer that question.
all right. Fair enough. That's all I had. Thank you very much for your time.
Thank you.
Here we
Thanks,
have
Mike.
hand, Miss Sawade. You can promote.
Okay, Ms. Swade, could you again state your name and address and spell your last name, please?
Hi, it's Marianne Sawade, 142 Johansson Avenue. How are you all again? There was a statement made about the stormwater analysis and not considering the whole area. I actually spoke with the men that came out to do the most recent analysis, and they were wary of talking to me because they were told the neighbors were hostile. I told them we're not hostile. We're just worried about what's going on. And we asked if they were doing an analysis of the storm drain elevations on Johansson, because that's extremely relevant in this entire thing. The whole problem is what's going to happen to our neighborhood. And all they're doing is measuring their little 13-acre area, and they're not measuring the levels of our storm drains in Johansson and beyond in our neighborhood. And this is the major problem. This is our problem, and they're not addressing it. So, I'm just making a point that they said they were not supposed to measure Johansson Avenue or anything beyond on the storm grate elevations. The most recent denial from 2008 on their a very similar plan. I don't see the difference right now. Only difference I see is the court pressure, the court, the court, I read it. I opened the court order.
Ms. Swady, I'm going to beat Mr. Folacastro. Do you have a question for either Mr. Ford or for Mr. Weiss?
Okay, yes. They said the site was cleared. They should know exactly what the site is cleared for.
First of all, who is the question for?
It's not for you.
Thanks.
I guess it would be for Mr. Weiss.
Keep it professional, so we know that. Who is it for?
I think she indicated Mr. Mr. Weiss.
I believe I am professional. I'm not.
Ms. Swady, I believe the question you indicated is for Mr. Weiss. Can you ask Mr. Weiss the question?
Good evening, Mr. Weiss.
Good evening, Ms. Swady. How are you?
Hello. The mound of dirt that appeared on your property sometime after your approval of the industrial site in '99, where did that dirt come from? Is it just from the site? Or was it brought in? Can you answer how that mound came about?
Sure. It's something I answered before, but I'm happy to answer it again. So I'm just going to give you the quick process. When you have a site, the site was treed, and we cleared the trees to the limits of the wetlands lines. And then I'm just going to tell you how it works. You come in with a bulldozer, and it strips off if there's 5 or 6. You never know how many inches you really have. Obviously, farms have more, but certain areas have more, certain areas have less. And what you generally do is, because you can't build on top of topsoil, you can't put anything on top of topsoil. So you have to clear off all the organic matter. And then once you clean up the organic matter, you push it all into a pile, and that's topsoil. That's what's used for planting and around trees when you plant them, and then if you're going to build any kind of if you're going to do any, obviously under grass, you want to put about 4 or 5 inches underneath wherever you're going to plant grass, where we're going to put trees. So this process kind of got stopped in the middle where we just pushed up and piled up the topsoil, and it was left there.
Now, in that original application, they didn't know about all the environmental concerns and didn't really care at that time, correct?
I'm not gonna answer that question because, but I will tell you that.
Oh, Robert, you didn't testify to that prior application.
Yeah.
Prior application is not before this board.
Thank you, Mr. Policastro. You're a true attorney. My concern is the drainage. The drainage, we are not satisfied as a community that is existing in Hillsborough.
Question, Ms. Swady, especially at this hour, please.
I'm just saying we're not satisfied that they have satisfied any resolution to the drainage.
That's a statement that we've discussed this before. Do you have a question for Mr. Ford or Mr. Weiss?
No, that is my statement. It's on record.
All right. We will, as I said, we expect we're going to have another one of these hearings, and you're going to get to make all your statements. And again, but Mr. Chairman.
And I thank everyone for their time tonight. Thank you so much for all of your time. We so appreciate it. I'm not speaking for myself. It's a bunch of us. I'm just a spokesperson. So thank you and good night. I appreciate it.
Don't leave, Ms. Swady, in terms of listening and what's about to come.
Right.
Obviously, Mr. Chairman, though we have apparently finished all of Mr. Policastro's witnesses, though I see several as professionals are sitting around. You've submitted all your testimony, Mark?
We have. We always reserve the right, but yes, we have. And we would.
You've submitted all your direct testimony. Let's try with that.
Yes, but we reserve the right, depending on what occurs, to present more witnesses. But yes, we have.
I am not. This is not a foreclosure. I'm simply trying to get to the evening over.
Yes.
Based on that, subject to any additional testimony that the applicant wishes to provide, based on what comes about, and or any further statements from the board's professionals, I assume, Mr. Chairman, we need another hearing date.
And we would request a special meeting depending on what the board's agenda is going forward.
So I turn to the man with the calendar.
Mr. Maskey, what's our calendar looking like in February? What do we have
You
on?
have a business meeting scheduled February 25th, which is currently open. There's nothing on the agenda. The next available meeting after that would be March 11th. So it's February 25th or March 11th.
Mr. Policastro, both are being offered. Pick it.
Is there anything before then for a special meeting?
That would be ostensibly a special meeting. The board has a meeting next week that they have other applications on.
Yeah, I just have to ask, is there anything respectfully before the 25th?
The board usually does not, and trying to get everybody together, including yours truly and Mr. Euro, is next to impossible. So, in fact, I'm not going to another meeting to be at the meeting on the 25th, if that's what you want.
Yeah, then we're going to take the 25th, and we will. Mr. Ford has concluded his testimony. Mr. Affenord has concluded his testimony.
All I suggest is, if you are going to have any or all of your prior witnesses testify as to what occurs on the 25th, they should be there, because we would like to move through this to a conclusion at some point, as do you.
But we have concluded, so we are not presenting Mr. Affenord on that date. If that's
Okay, Mr. Affenord is not going to be there. If you wish to present any of your other witnesses, as you have reserved, they obviously need to be there on the 25th.
Okay.
I believe we have an extension through the end of February, do we not, David?
February 28th.
Okay. Therefore, Mr. Chairman, the appropriate next action is a motion to continue this hearing to February 25th, 2021, probably 21, I wish it was 22, 21 at 7:30 p.m. or soon thereafter, as the matter can be heard without further notice. I will also point out to those who are listening, if you have anything else you wish to provide the board, In anticipation of your statements on the night of the 25th, the deadline for submission is close of business. Ooh, I got to do it in my head. Pardon me, close. I'm going to, Mr. Chairman, ask to do it a day later because the 15th is a holiday. Close of business Tuesday, February the 16th.
Okay,
So
so I'm gonna,
petitions, statements, etc. Please provide, as I indicated previously, Mr. Policastro and Ms. McManus will receive more things for them to review. And we will also extend the hope that Ms. McManus will also attend on that evening if she so chooses to do so. I know she's hiding right now. So it's a motion, Mr. Chairman, to the meeting.
okay, may I have a motion to extend the hearing to the 25th at 7:30 PM?
Without further notice.
Without further notice, thank you.
So moved.
I'm gonna give it to the mayor who's making the motion for his rank. Who is the? who is second?
I'll second that then.
All right, then the deputy second.
I always lose out to the rank. Yeah.
Hey, deputy.
Okay, do we need a roll call?
All in favor?
All in favor?
Aye.
Aye.
Anybody opposed? Thank you, Mr. Policastro and your witnesses for their patience this evening, and Ms. McManus for her appearance.
Thank you, and board members and professionals, as always, I appreciate it. Thank you for your,
Thank you.
thank you.
Thank you all.
Unless Mr. Maskey wants to disagree with me, Mr. Chairman, I believe the next appropriate item is a motion to adjourn.
Yeah, just want to just remind everyone, just as we stated, we do have a meeting next Thursday evening on the 11th. So as always, please let the planning board know in advance if you're unable to attend. And now I will entertain a motion for adjournment.
So moved.
Okay.
Second.
I got a motion and a second. All in favor?
Aye.
Aye. Okay.
Good night, everybody.
Good night.